Welcome to Baker's channel where stories unfold, covering trials, dramas untold. Grab your seats, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, dramas and fun, all we've got. Discuss, debate, break it down. Baker's channel, just the best in town. Lawyers spar, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, draws and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Damn, please let join the crowd. Baker's channel, we're live and loud.
I'm Jimmy. How y'all doing?
You know Laurie Shaver?
Yes.
When did you first meet Laurie Shaver?
This is in the summer of 14.
And where did you meet her?
I'm not Jimmy, but how you all doing? Good morning, good evening, good afternoon. Starting a little early because the feed went live and I don't know what time they claimed they were starting. So here we are again, you and I, my friend, just waiting for little Jimmy to take the stand. But no, day 4, let's be serious. Day 4 in the Laurie Shaver trial. State were supposed to have rested yesterday, I think, because all of the stupid questions by the defense attorney. And yes, I know a defense has the right to try every avenue, do whatever they need. But yesterday it became kind of not erotic, idiotic. That's quite some different thing. Because the man doesn't know the difference about Facebook and the ones who carry your signal through the router in your house. The questions he was asking were just too stupid. And we know, because he mentioned that in the opening statements, that they have an IT guy, a guy who probably had an aneurysm listening to that yesterday. But if everything is kind of like we sussed it out, but JJJ should be the first and maybe only person to testify today for the state, and then it's the defense. Defense will be calling the 7-year-old at the time, now 15, which we won't be able to see. We might have audio. Other than that, I think that maybe have a DV expert or something. And then the big question, will Laurie herself take the stand? That'll be the first poll of the day. I think she will. I think the attitude she showed in the videos, the way she's been interacting with her lawyer, he seems like she's running much of the show with all of the, oh, Your Honor, someone was on social media yesterday. So I think there's a good chance Laurie will take the stand. If she do so, it might be worse than I never remember his name, Reginald III, the guy who testified doing his closing statement, yes, I did it. But why? Hey, Nicola and Sky Bill. Shore Life Creations. What are you creating? That's an interesting name. Jedi Jizz. Reindeer. Haven't seen you in a hot second. And Venus Victor. And the one, the only. I slid into her DMs yesterday, and it was caliente. Right, Irish? You know what I'm talking about, girl. Talking about caliente. Good morning, Luna. And Ossie, how are you doing this morning? Matti Abianati. Good morning, Debbie. Hospice Jess. He was amazing. And Jess, when can I have you back on a Stabulate? I need to talk to you again. It's been so long. Yeah. Well, they did allow his testimony, just not anything about violence. I think people got that mixed up. It was the part about violence he testified about that wasn't allowed in. Yeah, it's so stupid. Did I have a haircut? Yes, I did. I was looking like a hippie. Carla Plikowski, good morning to you as well. Cinco stars. Hey, Jenny. Coastal home decor. Oh. So something sea themed to hang on your walls. That sounds cool. I used to, when I was married and I had a house, we had one of those 70s thing, I know, but I still liked it. That thick, like an ankle rope as is it the banister or what are you calling it on your stairs? And then some metal thingies to hold it up. That was nautical themed. I liked that. It was really bad to hold on to if you were drunk, but I liked it. Stephanie Bland, good morning to you. Tis Pelly. Let's do it. You'll actually check your Discord. Well, give me a time when we can do it. It's I can do it all night long, but I need a partner. Well, thank you. All of that for $20 and 10 minutes. Thank you so much, Debbie. Feeling better. Well, the leg isn't as painful as yesterday, but I've been keeping it. I've been resting a lot today. Jano, good morning to you. And Federowski, hello. Did I have a swag lamp? No, I didn't. My buddy has I believe it's an anchor lamp. That was cool. That's cool. I used to be in the Navy. I was only there for 9 months. Never sailed on a ship other than a ferry. But once you've been in the Navy, you're always in the Navy. Just listen to our theme song, In the Navy. La 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 la. Donna Kehoe, thank you so much. I try. Helen from Holland. It's always more fun with a partner. Isn't that the truth? Lynn from South Wales. Good morning to you, Lynn. Yeah, I just went out, got my hair cut, and then I did nothing else. I've been putting around in my house. But it's annoying. I miss sorry, I just got an inside scoop from my secret unnamed reporter in court. Really hard to figure out. But apparently, the inside scoop is a juror was present when Laurie's attorney was talking to the press yesterday after court. They are going to raise the issue with the judge and see what he wants to do. So another problem. It's been the social media. Now it's being present when talking to the press, which they can't be because he will be talking about things that might not have happened, might happen today. That's why you can't have jurors present, or that's why you can't talk to anyone. I actually had it Tuesday when I was leaving the court, we had a few witnesses in there, and some of them, because it's not a nice case, but some family members were standing outside, and one of them approached me, and I can't talk to anyone because I'm a juror, and they came up to me and said, "Hey, aren't you?" And I just kept walking. And she said, "You don't have to be an a-hole just because you think you're something." I said, I can't talk to you. And she stood there, yelled at me, I was an a-hole. Well, thank you so much. We have a judge in court, so let's see if problems will be brought up.
We were present in case number 24 CF 596, State of Florida versus Daniel Trenton Purdue. Present for sentencing. Please state your name for the record, sir.
Oh, this is another.
Raise your right hand. Do you solemnly swear or affirm that any testimony you give
This has
today?
nothing to do with that. So he has some other matters to take care of before we start trial today. So I'm just going to pop this off, and hopefully Mr. Purdue gets his due sentence. Well, it was better than the 29 sidebars we had yesterday.
I'm Jimmy. How y'all doing?
You know Laurie Shaver?
Yes.
When did you first meet Laurie Shaver?
This is in the summer of 14.
And where did you meet her?
I like Jimmy. Well, they have an annoying audio hum when they take it off the camera. Sue, how you doing, Sue? Everything fine? Everything's good? I hope so. But no, apparently again today it should be a really short day for the state. Maybe only for JJJ on the stand. Maybe well, they can't pull back rebuttal witnesses because there's nothing to rebuttal. Other than that, we had the lead investigator. I can't see who we are missing. We had MEs, we had lead investigators, we had all the tech guys, we had the financiers. So I think the only person they were lacking is with JJJ, and they probably didn't do it yesterday because we ended at shortly before 5. Yeah, I think, and he probably felt he couldn't be done with him at 5:30 where they normally ends. Hey, Holly Mac, how are you? Gotta open every show with Jimmy. Well, it's kind of like everything else. I have to do it in doses, which means I was trying to put him into my opening, but I couldn't. I have messed something up. I must have deleted some files because I can't get the OBS to work, and I can't find the raw file now. So I have to do my opening all over again. It should be in my the program I use to do all my graphics, but I can't find it. So I can't add it on. I was trying. You missed it. He was a good egg. He only slept with her for a month and a half, and he sold them a car. And when she came back for more and told about how bad Michael was treating her, he said, "I'm just banging you. I'm not your therapist." Probably not in those words, but kind of how I interpret it. How am I feeling? I'm feeling peachy. If that peach has a slight pain in its left leg. Helle Fisker. Well, thank you for being my fan in Vejle. Hope everything's good over there. It's raining down here. Nina Canadian. Lake Huron. Turtle Island. That's a cool name. Huron, that's were that the tribe in the last Mohicans that they fought against? The Huron tribe? Or I know that name for I know it's a Native American tribe, but weren't they in one of those movies? I am looking spiffy. I go to my barber. We just had a barbershop opening, so you can get that authentic barbershop feeling where you can be served a beer and they'll take care of you. Cost $120, $150 to get a haircut. No, I go to my Middle Eastern guy. I'm out in 10 minutes and it's $20. He does a fine job. That's not much to work with, and I just like it neat and tight, so I don't need someone to stand around and muddle it for me. What's my favorite kind of music? Elvis music. Curious because, well, actually, I had a running thing where every time we started a new trial, I did some AI music, but then I started doing all the panel shows and trying to connect with other creators, so I didn't have those 2 hours in the morning to sit and create music. So it's about time I make a new opening. I go past the Chevy dealership and ask if Jimmy would pop out of a suitcase. Well, ask if you can get a Tahoe cheaper if you let him. No, don't say that. Peaches are all gluteus. Then I'm feeling better because my gluteus isn't hurting. It's my thigh. Yo, what up? Everyone in Baker, are you feeling better? No, everyone, I'm fine. I have 2 herniated discs. I have pain all the time. It's pain is life, but I'm here. I'm smiling. Don't worry about me. I should have been on a train to Copenhagen to check into a hotel to get up at 5 a.m. tomorrow to get to an airport to get to Rome. So tomorrow, uh, well, tomorrow Marissa will start the show because I will have an appointment to get a deep tissue top of the thigh massage, almost granular massage. But other than that, you'll probably see me being a bit sad tomorrow because I won't be in Rome enjoying all the great architecture. I love going out sightseeing. I don't do much photography, and I'm not like the expert who can go around with a camera and capture everything. But I love going, just walking around, seeing all of those old buildings and churches, and I love Rome because it's such an amazing city. But the last time I was in Rome, I think I did something like 15 to 20 Ks in a day walking, probably not good on my leg. So, yeah. Your stepson's grandma is a distant cousin of Elvis. That's pretty cool. Who else? Is it Little D who's also connected to Elvis? Someone I know has something with Elvis to do. No, it's not sciatica. I have an inflamed muscle head, I think it's called. Um, so I've just I was doing Good Girls at the gym, and normally you get a little tightness in the area after doing Good Girls. This time it just I have aggravated the tissue so much that it turned into an inflammation. It hurts like hell, but hey, that's what pills are for. Yeah, Fedorowski, a lot of new Spanish videos. Go check that out, and I'm pretty sure within a few seconds, one of the mods, if they didn't already do it and I missed it, will be sharing a link to Mr. Fedorowski. If you like people who
Versus Laurie
can
Shaver.
go out and
Parties
film,
present, please
he is
identify
the channel
themselves
for
for the
you.
record.
Oh, sorry, Fedorowski, perfect transition.
Ma'am, please state your full legal name.
I didn't go to Graceland this time. The first time I was in the U.S., I was staying with my sister's foster family or school family when she was an exchange student. And he said, well, I was there for 2 weeks. And the first week, he came home and I was listening to Elvis and said, "Do you like that?" I said, "Yeah, I've been a fan of Elvis all my life." So the next Tuesday, we picked my sister up from school, drove down to Graceland, went to Graceland, drove back so she could be in school on Thursday because she could only get 1 day off. So I have seen Graceland, and we have a knockoff Graceland in Denmark. So that was amazing. And thank you, Bill, for being such a great man doing that for me.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Good morning, Jamie. So glad you could join us.
Morning.
I have a complaint from HR.
What?
At what anytime you want to say something, just pipe up and I'll shut up.
I will speak when I want to.
I'm Jimmy. How y'all doing?
Just say that, Jamie, and I'll let you talk. She didn't even hear it.
God.
No,
No, I didn't pull an empty law. I didn't hurt my groin. I hurt my groinular area. But thank you, Bad Dog.
All right, thank you. And are we conducting a proffer this morning?
Yes.
Okay, and the parties are prepared to proceed? Okay. All right, then we just need Miss Johnson.
See, a little bad dog swimming.
what is going on? Sorry. I
We're
missed.
having a proffer.
For who though?
Miss Johnson.
Which one is she?
Good morning. Please come up to the witness.
Jamie, just because I said you could talk, don't ask me questions. I have no idea about you. We've been doing this for 18 months, and I don't understand anything that's going on, please.
Stand. Please be seated. Make yourself comfortable.
Come on now.
Let me know when you're ready to proceed.
Let's bump it up.
Your Honor, as it relates to this offer, I know that a lot of my arguments are going to come about why this witness should be excluded, are going to deal with the fact that if we might possibly be able to talk about this hearsay for the purposes of this, I'm not going to be objecting in the middle of Mr. Bickle's questions. I'll let him argue about the admissibility of the Proffer statement.
Yes, sir. All right, and please state your full legal name and spell your full legal name.
Kelly Johnson, KELLY JOHNSON.
Thank you. And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? All right, thank you. Please proceed. Yes, sir.
Please support.
Yes, sir.
Miss Johnson, just state your name for the record, please.
I did, Kelly Johnson.
Okay. And do you remember being judicially appointed on this case involving Miss Shaver?
She is the lawyer for the kid who she's there to instruct her that she did know about her rights to not testify and what legal ramifications she could have by saying she pew-pewed her dad. And Holly Mack, thank you so much for the 5 memberships to Nina Canadian, Bad Dog, Tish Pelly, Jano, and Sean Life Creation.
Okay. If I can approach Judge and show her
Yes, sir.
Defense Exhibit A for identification purposes, which is the order. You look at Defense Exhibit A for identification purposes.
What is
that
this
the
audio?
order you're looking at wherein Judge Singletary appointed you to this case?
Yes.
And in the respective order, what was your understanding your obligation was?
I was appointed to represent the child as an attorney to I.
Okay. And the child's name?
Isabel Shaver.
Okay. And having been appointed on behalf of the minor child, did you meet the minor child?
Yes, I have.
Did you discuss with her the facts or knowledge of the case with her?
As with any client, I discussed the facts of the case, the applicable laws, and possible ramifications of taking any position.
So, did you discuss with Isabel? Did she express to you in any form or manner that she had any interest to testify in this cause?
She expressed a preference to me in a developmentally appropriate manner.
I'm sorry, speak up.
She expressed a preference to me in a developmentally appropriate manner.
Ms. Johnson, can you pull the microphone towards you a bit? It's adjustable and speak into it.
That's not an answer to the question he asked you. He asked you, did she express a desire to testify? And you just answered that she was in an appropriate approach. Age, Jamie, what I'm trying to say is she was answering in a way that because of her
Yes.
age. That's not an answer to what he asked her. Jude Curio, thank you for the 5 gifted to Opal Gypsy. Hey Joe, Watchdog, Dennis Eaton, and the Floofy Cat.
To the best of your
Hi,
ability. Thank you.
Pixie.
I'm not sure if I understood your answer, Ms. Johnson. Did she express to you an interest in testifying in this cause?
As I stated, she expressed a preference to me in a developmentally appropriate manner.
Okay.
I can't discuss the
The context.
anything that the child and I discuss as it's bound by attorney-client privilege.
Correct. Did you discuss when you were meeting with her, if she were to testify, the rights, constitutional rights, that she would be waiving by testifying?
Yes.
Did you express to her any legal penalty which she could?
For those of you who just jumped in, this is a proffer of the lawyer who took care of the 7-year-old at the time. He's trying to figure out if she would testify. She can't answer anything because she was her lawyer. But it's just to see if the kid would testify and if she have talked about it before. So that's why she's up there. Thank you, Rudy, and welcome.
Phase, if she were to testify and the state took action against her.
I advise her as I would any client.
Did you detect any infirmity with regards to Isabel if she were to testify, that she would have a problem testifying truthfully?
That's not within the scope of my representation of the child.
So did you feel that the child was being honest with you?
Again, that's not for me to determine. The scope of my representation as an attorney ad litem is to advocate for the child's what I feel is her position, if she's able to articulate that, and to advise and provide the any guidance I can in advocating for their position.
Did you detect any infirmities with the child?
She didn't have any problems communicating with me.
Did you detect any issues that would raise concern for you as a guardian?
I'm not a guardian ad litem.
Well, an attorney ad litem in this case, correct?
I'm an attorney ad litem. It's a distinct and different role than a guardian ad litem.
Did you detect any fabrication?
Again, that would.
Without going into any discussions that she had with you, did you detect any fabrication?
Again, I don't believe that I would be able to express an opinion about that. That's outside the scope of my representation as an attorney ad litem.
Based on what your client.
If you're talking about the main screen, yes, that's a little blurry. That's the court camera. The rest of us should be like we are normally. It's the same camera. No, I need to hit my light one more time, but I'll do it when I put things on the board. But the court cam is a little 1992-ish.
Had expressed to you, did you at any time meet with the office of the state attorney?
I participated in the proceedings consistently with my representation of the child.
Was that at the behest or request of your client?
In advocating for my client's position.
Okay. After that meeting, did the office of the state attorney contact you at any time to converse with you or your client after that conversation?
The child was subpoenaed to be deposed in the case.
No. Before the child was deposed and yet after that meeting you had with the state, did the state show any interest in meeting with your client or law enforcement to investigate anything that you had revealed to the state?
I don't believe that there was any participation in the proceedings until the child was subpoenaed to provide a deposition.
And did you appear at the deposition with your client?
Yes, I did.
And was the state aware that you were representing her?
I assume that they were
Okay.
aware.
Boomer, I got a feeling she doesn't like him.
Mark this as C, I guess.
Hey, Jessica.
I'll show you, which is what's marked as Defense Exhibit C for identification purposes. It's on the heading. It says supplemental.
If you haven't been following the case, it's about a lady who whose husband goes missing. She claims he's in Georgia. Some friend drove him there. That friend said, I never did that. 3 years later, they find him under a concrete patio she built around her fire pit, 3 feet down, with a 38 extra hole in the back of his head. Then she starts saying, I don't know, claims her boyfriend did it, her 7-year-old daughter did it, her 7-year-old daughter thought she did it, but it was her boyfriend, but she has nothing to do with it, other than she has used all his social media. There's a heavy circumstantial inference with IP addresses. She have used his credit cards. She has she has lied a lot about what, when, and where. She everyone is calling it the Bird husband murder trial. For me, it's more the JJJ trial, because she had another guy she was sleeping around with who was married, with whose name was Jay, and she got that tattooed in her heart near her JJ. That's why this case is interesting to me.
Discovery number 31, issued by the State Attorney's Office. Does this document carry your name?
Yes, it does.
Thus, you would agree the state was aware that you were representing Isabel Shaver. We knew that in evidence, because we've seen evidence at this time.
For purposes of the hearing, that's fine.
All right, without objection, Defendant's Exhibit C will be moved into evidence as defense number 1.
And A as well as.
I don't think he got any direct. He was just reaching out to him because they were talking about haven't seen him in a long time. That's how it started. It wasn't, oh, I saw something, or I did something, or I heard something. It wasn't that concrete when he tried to reach out to him again. I think there was something about something on social media, but I can't remember. I'm sorry. Why are they swearing in the beginning of this? She wasn't testifying. They have done it every day, and I have thought the same thought every day.
Any objection?
No, just for the purposes of this hearing. Okay.
Yes, sir. All right, Defense Exhibit A, without objection, will be moved into evidence as defense number 2. For the purposes of the proffer. And that's everyone's understanding, correct?
Yes, sir.
Okay, all right.
Yes, sir. Ms. Johnson, the other day, the issue arose, the state having been supplied a copy of the order by the court appointing you as the guardian, that you were not on an official witness list of the defense. You met with the state, correct?
What do you mean?
The state at a deposition.
Yes,
You traveled to the state and met with them, correct? To discuss your client's case.
yes.
They were aware you were involved in the case, correct?
I assume that they are aware.
Yes. They directed a pleading with your name, service on it.
They served me with a subpoena, yes.
Pardon me?
They served me with a subpoena.
They put a witness with your name on it, okay, care of you,
Yes.
okay? If called to the stand in this cause,
Thank you.
the defense would intend to limit your involvement just to the facts. Did you meet with your client? Did you advise her of her rights? Did you see any defect or deformity or issue that would preclude her from testifying truthfully? Is there any rule or anything that would prohibit you from asserting those facts before this court?
No.
Yeah. Judge, we had listed formally, and I've supplied it to the state, what's now marked as Defense Exhibit B, which is Kelly Johnson's name on a formal witness list to alleviate any question of any intent to call. She's expressed what her limited purpose would be. We move that into evidence at this stage. A copy has been sent by e-portal to the state attorney's office. And hand
I
delivered
said
here
good
in
morning to
Oakland.
you as the first one, Nicola.
We don't believe that any prejudice would inure to the state if Ms. Johnson were to testify on these limited facts and would be for the purpose of conforming and confirming the competency of her client to testify in this cause.
Has that document been marked as an exhibit?
Yes, sir. It's been moved in, it's been sent through the people.
Any objection to Exhibit B being entered into evidence for the purposes of the proffer? Okay, without objection, Defense Exhibit B will be entered into evidence as defenses number 3. All right, please proceed.
Good morning, Ms. Johnson.
Good morning.
So the majority of things that Mr. Wiggs was asking you about are conversations that you had with Isabel Shaver. Is that fair?
That's fair.
Okay. And those conversations that you had with Isabel Shaver would be out-of-court statements.
Correct.
And the purpose of putting those out-of-court statements in about your conversation would be to prove exactly what happened in that conversation.
Well, it would be eliciting statements made by my client and something that I could not testify to based on the privilege and confidentiality of our communications.
So he's asking you about hearsay out-of-court statements.
Yes.
Okay. And so you can't talk about out-of-court hearsay statements. You can't talk about opinions that you've already said, correct?
I mean, I guess I could testify to that unless there was an appropriate objection made and the court ruled that that I could not make those statements. But the other prong of that is my role in representing the child in this case as an advocate and as an attorney. I'm bound by the professional conduct rule.
Absolutely. And after it actually, the Mr. Wiggs actually sought you out and asked you to participate in this case, correct?
There was a conversation about whether I would be willing to accept the appointment.
And then he requested Judge Singletary.
Well, they are blaming her, but they're also blaming another guy. And in opening statements, they blamed her, but said she didn't do it, and then the JJJ did it. It's very confusing. But they're going to call a 15-year-old to the stand who was 7 at the time, is what the rumor is.
Appoint you.
I believe there was a motion filed, yes.
This was not a scenario where Mr. Wiggs asked the court to appoint an attorney and Judge Singletary just said, you know what, I think Kelly Johnson would be perfect for this, correct?
I don't know that.
Have you seen the motion that Mr. Wiggs filed where he asked for you to be appointed?
I don't recall if I've seen the motion.
After you were appointed, you would agree that there was multiple conversations between yourself and me in the hallways about anytime you want to bring your client to talk to me, I'm available. Do you remember those?
Yes, we did have conversations.
But you, serving as a good defense attorney.
Well, at least 4 times, but because the first story was he moved to Georgia.
He would not allow her to speak to me until I provided a subpoena, which then gave her immunity. Is that fair?
That's fair.
Okay. So it's not that I never contacted you. You, as a competent defense attorney, wanted to protect your client and wanted to wait for that subpoena to be issued.
That and I also needed to make sure that my client was well informed on and advised in their participation in this proceeding.
Nothing further, Judge.
All right, Mr. Wiggs. Please, the court. Ms. Johnson, with regard, you practice criminal law, correct?
Correct.
Now, the state just went through a litany question and stated, in essence, anything you would say would be hearsay of what your client said, correct?
The rules of evidence say, if I testify to an out-of-court statement, that's hearsay unless there's an exception to that.
Correct. As a criminal attorney, you appear in court frequently, correct?
Yes.
And
Plural.
at any sentencing, any and all sentencing, in fact, every sentencing, every attorney has to go through a litany with the court about the rights that they've advised
It's the defense who wants to call her.
your client on, correct?
Correct.
The right to remain silent, correct? Maximum penalties, correct? Their presumed competence and desire to enter a plea,
Yes.
the waiver of appeal, correct? There are 6 different things that go into that waiver of discovery and the ability to proceed at that time. You also make a representation, do you not, that you believe the client, having discussed these facts, is competent to enter the plea, correct?
Yes.
And none of those go into a discussion that you have with the client about what they said, what they did. It's just a statement of their desire to move forward, correct?
Correct.
Okay. Now, if you were called to the stand in this cause, do you have the ability to represent those rights that you'd advise the client of and the preference of the client to move forward without discussing the exact conversation, like any other criminal case?
Yes.
Thank you, Judge.
Thank you.
All right, and Ms. Johnson, you're excused from further testimony, and Ms. Johnson is to remain on standby, is that correct? All right.
Assuming you're saying that any of that is actually admissible.
I haven't ruled yet, but knowing that I haven't ruled yet, would you like Ms. Johnson to remain on standby?
Yes, sir.
Okay, please remain on standby. You may step down from the witness stand. Thank you.
Jamie is pretty. Yes. That's why beauty on a budget tomorrow.
Okay,
at noon.
proceed with argument.
Thank you.
Judge, Ms. Johnson was appointed by the court recognizing there's a conflict. I can't represent her. I can't talk to her. Ms. Johnson can verify I haven't talked to her. There's been no influence. The child is aware of these constitutional rights. It's a summary proceeding, not revealing any conversations that Ms. Johnson has had with the client, just that she believes the client's competent to move forward, and that's the desire of the client. It's a perfunctory function. The state has been aware from the moment Ms. Johnson was listed in this cause as to her interest in the matter. The state's not prejudiced in any respect. If we were to call up a Richardson hearing and direct this towards a Richardson hearing, the state could point to zero facts how they've incurred any injury, damage, or prejudice in this cause by calling Ms. Johnson at this stage. So we'd ask that, she's been listed formally. The state's known who she is. She's been to their office. They've spoken to her in the hall. There's no reason to exclude her, just for purposes of clarity and allowing the matter to proceed and finish the matter up in an orderly process.
Tell me exactly what you intend to elicit from Ms. Johnson.
Correct. Okay.
Thank you.
Yes, Judge. Anybody who testifies, the court has to be satisfied, as in a criminal case, that they understand their rights, they intend to testify, they understand their obligation to testify truthfully, and intend to do so. That's really a pretty simple process. Because
You were
Ms.
right
Johnson
next to the
was
microphone.
appointed as the guardian in the case, we want to elicit that there's been no tampering, we haven't tried to communicate with the child, and she's been the one in charge of directing all conversations. So she would just provide that function of saying, I've spoken with the child, she understands her rights, she understands her responsibilities, it's her desire to move forward, understanding the potential charges that can be levied against her, and that she believes through her conversations that the child's competent at that stage. That's it. It's pretty perfunctory, to tell you the truth. If you don't have Ms. Johnson, the child can still testify. It just draws the court to have to make every little decision in that case. The state is taking the position, well, she's older now, you don't need Ms. Johnson. That's what they were advising us the other day. I think it's advisable to have Ms. Johnson just to clear up any ambiguity or issues regarding any competency with regards to the minor. If the court is not satisfied with that, we'd ask that the court have a Richardson hearing and at least have the state provide proof that they've been in some manner prejudiced by this. So we'd rest on those issues and that argument at this stage. Thank you,
All right,
Judge.
thank you, sir. State.
Your Honor, my motion made it very clear that I'm not asking Ms. Johnson to be excluded because of a clear discovery violation by Mr. Wiggs. I put that information into my motion because Mr. Wiggs made an affirmative representation to this court that he had in fact listed Kelly Johnson, and that is just not true. I'm not asking her to be excluded because she was disclosed.
Hey, all shizzy raiders and people who are dropping in a little late. We are having a proffer of the lawyer that the 15-year-old kid had when she started to express that she did it. As always with this defense attorney, it's kind of a clown show. It's going to be denied by the judge. I'll bet my pantalones on it, because he want to elicit out-of-state hearsay statement from a lawyer, probably breaching attorney-client privilege. It ain't gonna fly. I don't think so. But we haven't started. But JJJ hasn't been on the stand.
Late. So the need for Richardson hearing and discussions of any sort of prejudice because of their late disclosure is not necessary. The reason why I am asking her to be excluded is because she can offer no testimony in this case. Everything that has been asked of her has been about out-of-court statements that would be hearsay, and he tried to elicit opinions as to this witness's veracity, which is inappropriate. And the decision as to whether or not any witness is competent is for the court. And the common law rule actually dealt with the fact that children under the age of 14 just are not competent. That has been abrogated by years of case law, and that is where the questions regarding, do you understand the difference between truth and lie? Do you understand the difference between fantasy and reality? Do you understand the concepts of making a promise, and will you be truthful in order to determine whether a witness is competent? This witness is now 16 years of age. I don't even believe that inquiry would be necessary due to her age at this point, and she could just take a standard oath. But if the court, in an abundance of caution, wanted to make those inquiries, that would be fine. She's given a Child Advocacy Center interview, which was recorded, where she has fully established her competence and the fact that she understands the difference between truth and lie. She understands the difference between fantasy and reality. She did it again during the deposition. There's no reason to question competence, and there's no reason to have Ms. Johnson come in and give opinion testimony about her competence. And once you go through those issues, which is what Mr. Wiggs has proffered the testimony to be, we are left with nothing. And so, since we're left with nothing, that's why this witness should be excluded.
Judge, I would disagree with the state. The state's saying this is opinion testimony at every sentencing conducted in this court or any court. The attorney has to render an opinion to the court. I believe my client's competent to enter this plea. So to say Kelly Johnson has no bearing or issue in this case is a misrepresentation to the court. But the state was advised of her, and it was court appointed. When I advised the court the other day, she had been listed. She was court appointed, of which the state had full knowledge. The reason we sought Ms. Johnson out was to create a barrier in light of the charges that the child could be facing. It's a safeguard for the court, irregardless of age. Okay? And we don't want it to appear that this child has just come in here and somebody's just throwing the child under the bus. That she does have a representative that's gone over certain things with them. But certain opinions, as the state's offered a lot of opinion testimony through the witnesses in this case, it is appropriate. It's appropriate in any sentencing, and opinion is proper at certain times.
And Ms. Johnson was appointed in March 15th, 2022, correct?
Pardon me.
So it's been a 2.5-year process.
Correct.
It wasn't as if Ms. Johnson was appointed a week ago.
Right. Yeah. And like I said, I'm not like.
It's not about the Richardson hearing. It's about getting to know her client and knowing her client and being the attorney ad litem for the past 2.5 years. So in terms of Mr. Wiggs' request, I'll grant the request, and for the limited purposes requested by Mr. Wiggs, Attorney Johnson's testimony will be permitted.
Oh, Jamie, I lost my
But the
pantalones.
questions
Her
regarding
pantalones.
And what are they going to ask her? Were you appointed to her? Yes. Did the state ever approach you? Yes. Was she age appropriate? Yes. Did she tell? Can't answer that. Objection. And she told the state what to do. I can't answer any of those questions. Well, I can answer those questions unless there is a objection ruled based on hearsay rule. So she don't want to testify.
Oh no.
I now have to lose my pantalones, Jamie. I will be right back.
his inquiries into the veracity of this witness, which Ms. Johnson refused to answer, I would ask that those questions be excluded and not be asked.
Yes, you make the objection at the appropriate time, not try to get every little ruling and pre-trial like this, Judge.
I believe Attorney Camuccio doesn't want the bell to be rung. Is that correct? Because he cannot ring the bell.
And if I'm aware that there is something that would be improper to be presented to the jury, it's my job before it happens to bring it to the court's attention, which is what I am doing.
So please not inquire as to veracity or perceived veracity by Attorney Johnson.
Very well, that's fine.
All right. Is there anything further?
Yes. It has come to my attention that yesterday, after the court proceedings, that there was a time frame out in front of the courthouse where Mr. Wiggs was speaking with the media on camera with the Shaver present. There was a juror that was sitting on the courthouse steps in proximity to that. I'm not saying Mr. Wiggs. I don't even know if he knew that she was there, but the issue that there was a witness present while Mr. Wiggs was obviously discussing the case. Sorry, a juror there while Mr. Wiggs was discussing the case with the media. I believe we need to address the particular juror is Mercy Langley. Langley, juror number 10. She was the juror that Mr. Wiggs had concerns about on the first day about having her head down, and potentially not paying attention. She's also the same juror that during one of the bench conferences seemed to be carrying on some sort of conversation. So I just believe we need to have the court bring her in, make inquiries about that issue, and then
About the issue with Mr. Wiggs giving the interview, or about the conversation?
probably need to take care of both. At this point, we have at least two red flags with this particular juror, and I think we should explore that potential third one. Just have the court inquire about those two issues, and then let her go back in the jury room. Then we can figure out if we just need to go to one of the alternates, or if Mr. Wiggs, based on the prior concerns, that juror just wants to have her removed, still sit on this jury through the pendency of the case, but replace her with an alternate. At this point, we can do that as well.
All right, I will inquire of the juror, and we'll call the juror out individually. Are the parties ready to go?
Yes, sir.
All right, then please call out Miss Langley, if you would. Thank you.
Uh-oh. She's gonna get in trouble. I'm kidding. So she had her head down. She was chit-chatting while things are going on. And now she's sitting over listening. We'll see.
I swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God. All right, and you're not in any sort of trouble. I just have a few questions for you. And were you sitting on the courthouse steps yesterday?
Yes.
Okay, and when was that?
I sit out there every day at 5 o'clock because that's when my grandmother comes to pick me up.
Okay, and did you see
She sounds like a
Attorney Wiggs
child.
seated at the table next to his client outside?
Yes, I did, and I tried not to. Well, I didn't look at them. I tried to pretend like I didn't know them.
And that's fine. Did you hear him say anything?
No.
Okay. Did you see Attorney Wiggs giving an interview?
Yes.
Okay. Did you hear any of it?
No.
Okay. And also yesterday in the jury box, there was a conversation. Were you speaking with the other jurors?
Yes.
Okay. And about what?
I don't remember.
Okay. Don't recall. Were you speaking to just one other juror or multiple jurors?
I think it was about one of the photographs that made me uncomfortable.
Okay.
That was it.
All right. Do you recall which photograph?
It was one of the sexual ones that was being shown on TV.
Okay. All right. State, any questions?
Yes, sir.
Okay. Mr. Wiggs? All right. All right. At this point, Ms. Langley, you'll return with the other jurors, and we will call you in shortly. Thank you.
She sounds like she's 5 years old.
Yeah.
Oh.
All right. Based on that, what are the parties' preferences?
I asked the state, they raised it. They've heard the testimony. It's fine.
Okay, the juror does not need to be excluded. Okay, Mr. Wiggs? Okay, so based on the stipulation of the parties, Ms. Langley will remain on the jury. All right, thank you.
But when the jury does come in and you go through the normal, media,
Yes, sir.
can you also give them a reminder, though, that they're not to start deliberations until everything is done, not to talk about any particular evidence? I'm not saying that.
And I believe I always have.
Okay.
Yes, sir. Not to speak with each other or anyone else. So, all right. Anything further?
No.
All right, please call in the jurors. Thank you.
I just like when she said, I just pretended I didn't know them.
See, Jamie. My
What?
pantalones. My pantalones as I lost.
Oh, you lost your pantalones.
Well, let's speed it up. Nothing's happening.
Mm-mm.
I thought it was his the daughter. She sounded 15.
I know.
That was weird. So yeah,
Randy did say some of them were young.
a friend of mine was just called for. Entire jury got dismissed because one idiot decided to Google stuff related to the case. Oh yeah, that's annoying, especially if you don't do it. If someone comes in and said, "Hey, hear this. I was watching this stupid Dutch guy, and he said she's absolutely guilty." Then and you're going to lose that $6 paycheck a day.
I know.
All the members of the jury have returned. I have some preliminary questions for the jurors. Has anyone spoken to anyone about the case? Any of the jurors, have you spoken to anyone about the case? Have you spoken to each other about the case? Everyone has answered no. And has anyone done any research regarding the case? Has anyone viewed any articles or newscasts on the media, read about it? All right, and everyone has answered no so far. Has anyone seen the attorneys or interacted with them since yesterday? All right, and everyone has answered no. And again, please do not discuss the case with each other or begin any sort of deliberating or deliberations prior to the conclusion of the case. So have you all followed those instructions? Okay. All right, any inquiries from counsel? Okay. All right, then please proceed.
State calls Jeremy Townson.
Jay.
Yay!
I
Here
just
he
lost my
comes.
pantalones in a bed.
In a bed.
Jamie is awesome. Baker's okay too. Yeah, Jamie, again, whenever you want to talk, because I am hindering you in talking.
Stop hindering my amazing
First
personality. Come on.
I love
my
that
freedom, my freedom of speech.
I love that before the show you said, well, I don't know if I have anything to ask. And then I get yelled at for not letting you speak.
Yeah, exactly.
We've only been doing this
that.
for 18 months.
I said, do you really want me on the show? Because I really don't know what to ask. And then we get yelled at.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed.
Oh my. That's a totally different type than the other ones you had.
Please state and spell your full legal name.
Jeremy Townson,
Oh.
JEREMETOWNSEND.
And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Now that
Great. Thank you. Please
jacket
proceed.
looks weird on him.
Please introduce yourself to the jury.
Yeah, but he looks like
That's
a
right.
manly man. He doesn't look like the twinks he's normally hanging with.
No, but they're very
It's
pointy.
because it's too small and there's too much stuffing. So what all us men should learn is whenever we are going to sit down, just do the little tuck in the back and don't do it on a rolling chair. Then you tuck your jacket so it slides down on your shoulders, or else you'll get that hunched up look.
Yeah.
It's something guys should learn, just like girls should learn. I don't know. What do girls need to know? Crocheting.
Oh, crocheting. That's what we need to know.
I don't understand women, Jamie. I've been single for too long. But men, if you're having sons, teach them the little tuck trick, or else you'll look like you never wore a jacket before in your life. And it'll give you a bigger profile because you have all that padding in your shoulders, so it doesn't look like it's riding up on your shoulder. This is Beauty on a Budget with the Baker.
Yeah. See? You can do the man part.
Yeah. The man part. Wash your face before you wash your... And then you'll be fine. That's the male beauty pageant.
Is that all you need to know? All right.
Jeremy Townson.
Townson, couple of questions.
And pluck nose hairs.
Are you currently having a jury?
Yes.
And when did you retain?
January 2022.
Prior to retaining an attorney, had you spoken with law enforcement
Yes.
about the matters of this case?
Yes.
And had you spoken with them multiple times prior to retaining an attorney?
Yes.
And why did you retain an attorney in this matter?
When my name came out as part of this case, my wife and I felt that we would retain an attorney to help us through the process, help us understand the legal side of this.
But you were willing to talk to law enforcement on multiple occasions before ever doing so?
Yes.
This is the guy whose nickname is tattooed on her fun box. Yes. This is the JJJ.
And you responded to all requests to speak with officers?
Yes.
Have you ever been in the military?
Yes.
And first of all, what branch?
United States Army.
When did you serve?
Served from 1998 to 2003.
And why did you leave the military?
I was shot 3 times in Afghanistan and was almost killed. Was medical retired out.
And the jury has seen photographs that have been shared with yourself in the paper already, some of them full.
For the love of God. Yesterday, audio was okay. Today, we can hear him nose breathing and we can't hear the lawyer. And this is actually good questions. For those of you who can't hear, he obtained a lawyer when he heard his name was mentioned in connection to this case to advise him and his wife what to do because he didn't know it. He was in the U.S. Army 1998 to 2003, medical out because he was pew-pewed 3 times in Afghani hole and almost died.
Body shot. Where were you shot?
Through both my legs, and one right through my side.
Now, do you know Laurie Shaver?
I do.
How did you meet her?
I met her at one of the public parks.
And about when did you first meet her?
September 2015.
She
And
gets around.
what were you doing at the park?
I had my son there.
Are you married?
Yes,
How long have you been married?
16 years.
How old was your child at that time?
About 5.
And what was the kind of home-work relationship? Did you work or the time frame? What was going on there?
My wife works. I'm retired out of the military.
And when you met Miss Shaver at the park, did she have any of her children there?
She had her son.
And did you all begin some sort of, did you chat with her? Did you start some sort of relationship? What kind of developed from there?
She approached me and asked if it was okay if her son played with my son.
Do you see her in the courtroom here today?
I do.
Can you point her out and identify her by something that she's wearing?
She's wearing a black shirt with white
Which seat is she sitting in?
next to Mr. Wiggs.
And when you would communicate with her, would she call you Jeremy or would she call you something else?
Jay.
After that first time you met her at the park, did you see her again?
Yes.
And
For those of you who, until they fixed the audio, couldn't hear, he met her at a park where he was with her son, and she asked, "Can my son play with your son?" I have heard about us single guys with kids can use that as a pickup, but I never ever seen it happen in real life. This girl was hot-blooded. That means she's a freak, Jamie.
Okay.
was that also at the park or was that at another location?
It was at the park.
At some point, did you all exchange phone numbers?
Yes.
And when approximately was that?
About the 3rd time I met her.
Did you all exchange text messages and phone calls?
Text messages.
The
Yes, he dipped it so well that she got a tattoo right above her fun box with his nickname in it.
After starting to text back and forth, at some point did a physical relationship begin?
Yes. Yes.
About when did that happen?
First week of December 2000.
Marissa, do you just leave your kid because it's playing with some other kid? Oh, how is that working? Oh, so you can just get a play date and you say, "Can my kid play with your kids?" And I really don't like my kid. You just walk off and the other one is going to take care of it. Not know. That's not nice, Marissa.
2015.
How often would you see her?
1 to 3 times a week.
And when would these visits occur?
It would occur during her lunch break,
Did
which
she
was,
work at home?
yes,
And when you would go during the lunch break, were her kids there?
no,
Where was your son when you would go over to the house?
in school.
Did you ever go over to her residence and spend the night during this time frame?
No,
During any point in your relationship, did you spend the night over at her house?
no,
And we've discussed the fact that you were married at that time. Is it fair to say your wife did not know about these occurrences?
Objection, Judge. It's opinion, testimony, speculating about his wife's understanding and factual state of mind.
I'll rephrase, Judge.
Sorry, did you have knowledge of it? Did you know whether your wife knew or not?
my wife did not know.
You definitely didn't tell her.
No,
Objection, meeting.
All right, overruled. Please move on.
You're not going to win it.
Had you stayed out overnight and spent time away when your wife was around, that would raise suspicions. Is that fair?
correct.
Meeting, Judge.
Sustained.
Were you trying to avoid raising your wife's suspicions?
Yes,
Did she tell you about her marital status?
yes,
And what did she tell you?
that she was going through a divorce.
Did she tell you her husband's name?
Michael Shaver.
Did she tell you where he was?
She said that he had left with a friend in a vehicle.
And when did that happen in relation to when you started this physical relationship with her?
When she told me that Michael had moved out, that was November 2015.
And so the time frame that you started going to the house was after that.
It was the first week of December.
During the course of the affair, would you exchange text messages, phone calls, and photographs?
Yes,
Are we going to see photographs? Hey, honey, I just had made this made for you. Please. And today show us the screen. And Zach, I will accept your pre-penance for whomever you might offend today. It's probably Jamie.
Nah. He
Hey, Mama
tries,
10.
but no.
So she tattooed her coochie while Michael was still alive. No, because he didn't get over there till after he was stopped breathing. So yes, he was married, and he's still with that wife. Some women, yeah, right?
And during this time frame, what was the status of your marriage?
my wife and I were
On a break.
not in a good place.
So
We
I'm
were
just gonna go
kind of
bang a
going back
lady
and
at the
forth
park.
if we were going to stay or get a divorce.
Was there ever a time that Laurie Shaver expressed to you that she wanted you to leave your wife to be with her?
Yes,
And was that what you wanted?
no,
Did there ever come a time in February of 2016 where Laurie Shaver was upset with you about your status with your wife and your refusal to leave the marriage?
yes,
And during that time frame, were there text messages about that?
yes,
Showing you what's been previously been marked for identification, showing defense, states QQ.
Look at that.
Any minute now. Any minute. Come on. What's going on? Well, we can speed it up then. Is it a sidebar? Do
I
we have
think
the first
so.
sidebar today?
I
He
think
said
so.
we're gonna mark it off as an official sidebar. First of the day.
Or
29 yesterday. What number will we get today?
I assume it's a sidebar because they want to show a picture. And you know Mr. Wiggs has got to look at it.
Yeah. 45% says yes, please, to will Laurie take the stand. 28% says yes, and 26% says ain't no way, Jose.
I mean, I don't think it would be a good look for her because I don't think she is very, like, sympathetic.
That's a baseball.
But
What's a baseball? Who is this man God understand? Wowza. Grey Witch, this is the man who met Laurie in the park while out with his son, started having afternoon delight, boo, with her while still married. After Michael disappeared, he started coming over to her house to have more morning, afternoon, night delight, boo. So all the ladies who got a little moist o'clockish when he showed up lost it really fast when they found out he's not a good guy, because him and his wife had problems. So he was banging Laurie. He was banging her so well she got a tattoo on her fun box with his nickname in it.
Stop.
On La Lalas de Tuna.
Say it like that.
La Lalas de Tuna.
This HQQ is an excerpt from Facebook records already in evidence from Michael Shaver. Do you recognize those text messages?
Yes.
And first of all, how do you recognize those text messages?
Laurie sent those to me.
And does it include communications from you and
Laurie cut off his hair and he lost all his strength. That's a Bible joke, Jamie.
I don't get it.
That's the story about Samson and Delilah.
Oh, you
You
gotta tell
remember
me. No.
Sunday school this Sunday, where we're going to talk about Samson, Delilah, and how he turned over the temple. Jamie will present the story.
Yeah.
her back and forth?
Yes.
Your Honor, at this time, the state will move states Q2 into evidence. The state's
45, I believe.
Same objection, Judge.
Okay, objection is overruled. State's QQ will be entered into evidence of state's number 45.
go ahead and publish. Go ahead and refer to the exhibit that you have there. First of all, there's a couple phone numbers on here. On that first page where it says receiver 352-431-01419, whose number was that?
I don't recognize it.
Okay. Well, what about 352-613-4100?
That's mine.
Okay. And these are all text messages. You recognize the messages from the content as being between you and Ms. Shaver?
Yes.
Okay. And the first.
Sorry, again, I'm just. Helen said, it's still unclear to me who helped her bury the body. Remember, he was digging out a dog pond in the yard. So there could already have been a pre-made hole that she stuffed him in. That's what I got out of all the questioning yesterday. That she might have wrapped him up in the top and just dumped him. According to Brandy, Laurie's body language has shifted since Jay is on the stand. She is leaned over to the side and had a visible reaction when Jay said he didn't want to leave his wife for Laurie. She's also shook her head when he identified her as soon as he looked away. Again, body language, take it for what it is, but I trust Brandy's feelings about this one and her observations.
Message that I want to draw your attention to is on the first page, February 25th, 3rd, 2016. Was that a message from Laurie Shaver to you?
Yes.
And up top there in the white, this is one at 10:17 p.m. What was the content of her message to you?
Why did you lie to me?
Okay.
That one?
Yes.
Yes.
Go ahead and read the whole thing.
Why did you lie to me about Saturday night?
And then moving on to the next page, 10:03:48 p.m., still February 23rd, 2016. What was the content of the message you received from the shaver there?
No wonder why you shaved your beard.
Okay. And what about the first message, the 10:03:48 on the bottom?
The neighbors?
Yeah, that's it.
Yeah, neighbors my
You can go ahead and say it.
neighbors my ass.
And when she's talking about neighbors my ass and no wonder why you shaved your beard, what is she referring to there?
I had shaved my beard completely off. I had a little smaller beard, kind of like yours, and shaved it all off. And she was saying that her neighbors could vouch for the affair.
Okay. Going on to the next page at 10:08:45 p.m. On the bottom in the gray, what is the message that she sends to you there?
Nice wedding ring. Thought you didn't wear that anymore.
What is she referring to there?
I had my wedding ring I had put back on. Had a picture with my wife. It was posted on Facebook.
And did this cause arguments between you and Laurie Shaver?
Mr. Meathook, allegedly, this is how it looks. We haven't seen any photos of it yet, but this is how I interpret it.
Will you stop? Daytona tat.
Yes.
That was in late February 2016.
Yes.
Sometime after that, did you learn that your wife found out about the affair?
Yes.
And how did that come about?
My wife contacted
Jason Momoa, I will agree on that one, King Paco.
me April 12th, 2016. She had received flowers.
And then did that expose the relationship between yourself and Laurie Shaver to her?
Not at first, because she asked me who Mike was.
Okay.
I did not know who a Mike was. Once she checked her Facebook and seen the messages from Mike, it started to come out.
And that was when?
April 2016.
At any point when you were over at the Shaver residence, was Michael Shaver there?
No.
At any point did you arrive on a scene where Michael Shaver had been shot?
I say what?
At any point did you arrive at the Shaver residence or any other place where Michael Shaver had been shot?
No.
At any point were you involved with any sort of altercation with Michael Shaver?
No.
At any point did you shoot or injure Michael Shaver?
No.
At any point were you involved with disposing of the body of Michael Shaver?
No.
And after the affair was exposed, what happened with your relationship with Laurie?
I cut it off.
Nothing further.
Thank you. Mr. Wiggs?
Yes, ma'am. Please support.
Yes, sir.
Let's go back to the original part of your testimony, Mr. Townson. You represented, you had tension with the wife and you broke up with
Didn't
her.
break up.
Well, you weren't seeing her, right? You were just sleeping with her?
With who?
Your wife.
Say it again?
I gotta get so many clips from
Wait,
this one
what?
because you broke it up with your wife. I didn't break it up, so you're just sleeping with her. No, he was married to her. You
He was
numbnuts.
sleeping
He
with
was
both
just
of
sleeping
them.
with Laurie.
Yeah, or he was probably sleeping with his wife and Laurie, maybe. Who knows? But
Yeah, but
still.
he was still married. He didn't break it off with her.
Yeah.
So technically, having sex with your wife or even staying at the same house isn't the same as gonna have some afternoon delight. Yeah, you were sleeping around, weren't you, with your own wife? You were unfaithful to Laurie. Oh,
Yeah.
he's such an idiot.
Well, we'll see where he goes with this one because that was confusing.
Yeah.
You were still living in your marital residence, correct?
Yes.
And you stated earlier y'all were having problems, the two of you, correct?
Yes.
So you guys are having problems and you're cheating on your wife, correct?
Yes.
And at the same time you said, but I don't want to end the relationship, correct?
Correct.
Okay.
That's how most cheat.
So you stated that you go over to Laurie's
yeah.
about 1 to 3 times a week, correct?
Correct.
And what time would that be?
11 to 12.
Okay. Never any earlier, correct?
Correct.
In fact, you went over there more than 1 or 3 times a week, correct?
No.
In fact, you got Laurie pregnant, did you not?
No.
Oh, geez. Did she say
You stated
that?
that you never spent the night there, correct?
Correct.
So if anybody were to testify they saw you spending the night there, you know where that may be coming from? Somebody look like you know?
I would not know who would say I'd stay the night there because I never stayed the night there.
You ever represent to Laurie you'd protect her from Michael? That you were a military guy and had special training?
Not in that sense, no.
That you were in black ops?
No.
Okay. Your position.
You ladies out there, let me tell you a secret about men. When we are trying to invade Los Pantalones,
Stop.
especially if we have a little bit of connection with the military. If we think we can get one night in heaven, we will tell you how much we were special forces, because we know most of you, thank you ladies who did the service, won't understand the difference between a Marine specialist and a Delta 6 operative. And if we tell you that story, we know you can never check it because we'll tell you, well, I would love to tell you about it, but you know, it's on the kibosh. We know we are going to tell all your girlfriends, so we may be able to sleep with one of those two, but most special forces guys never were in the special forces. Only Valhalla. He is a closet specialist in the furniture department of the Army.
Okay.
We've heard on your direct examination that you met her in September of 2015, correct?
Correct.
Okay. Have you ever made a statement inconsistent with that?
Not that I'm aware.
Not that you're aware of, okay? I'm going to show you your deposition, page 5, beginning on line 1 through 12. I want you to read that to yourself.
What line?
11 through 12.
Well, it's the same the service ladies tell you. I'm a virgin.
Refresh your recollection.
Why
Hang
does
on.
it burn?
It just goes on to say how I met her.
No, I asked you, have you made a statement inconsistent with that September of 2015 date?
Valhalla?
In fact, on line 11, you say, I met her in the park. I don't know when. I mean, it was a long time ago. Correct? That was your statement earlier in time, correct?
Correct.
Now, we're at trial years later, and you've got it pinpointed to a particular month and year, correct?
I don't have to pinpoint it
You did. On your direct examination, you said September of 2015, correct?
as I went back.
Sir, did you not say on direct examination
Oh,
September
maybe he-
2015?
Correct.
Did you not? Earlier, you're telling me, I don't remember when.
Oh,
Correct?
sir,
Okay.
get out of here. So,
In fact, you went to the house, spent Christmas with the Shavers, did you not?
No,
If anybody were to take the stand and say otherwise, do you have any idea why they may be mistaken about that fact?
Oh, I hate it when he goes into, oh, I'm the nice old granddaddy talking to you now. All right.
mhm.
Such a condescending prick.
I was there before Christmas, but I did not go there and spend Christmas with the
Okay.
Shavers.
Well, how long were you before Christmas?
I was there the first 2 weeks. Kids got out of school for Christmas break, and I was home with my family.
Okay. So how long did you spend during that time period around Christmas with the Shavers?
The first 2 weeks of December 2015.
Ever go shopping with the Shavers?
No,
Since Laurie, since you went back to your wife, excuse me,
I didn't leave my wife.
well, you were over there with Miss Shaver having an affair, were you not?
Well,
Correct.
he's
I
just
would
going
say
over
that's
there.
gainfully spending time with your wife, is it,
What?
sir?
No,
And when you went back to your wife, is it not a fact you continued to follow Laurie?
no,
Never met her in a store?
no,
Never pulled up to her next to the light?
no,
Never drove by her house?
no.
Okay. So you testified you were in the military, I think, between 2000 or 1999 through 2003, correct?
1998.
1998.
98, okay. And 2003, correct?
Correct.
And you suffered this injury,
Mhm.
correct? Have you worked at all since then? Nursery?
I did work.
Okay. And you're receiving government aid and assistance, correct?
Yes.
Did you tell the government about that? You're working?
Objection, Your
I-
Honor.
What?
What does that have to do with?
So you do the Al Capone. You're gonna get him on tax evasion. Come on now, brother. I know she's a cray BB, but still, this is too low. He got shot 3 times. If he might accidentally have earned $500 by helping a friend install a computer, let it slide. He took 3 bullets for you and your freedom. So don't be an absolutely dickweeb. And I can't say that. And rat him out for earning a little. I don't know what you call it in Denmark. We call it. Well, I can't say that. It'll probably be seen as this column money because we back in the day you earned it at night and you don't disclose it. That's absolute. This is lower than anything he did before. Oh, you cheated on your government paycheck. Yeah, they probably
They want him
cheated
to
him as
be,
well.
yeah, they just want to show he's like dishonest.
Yeah, dishonest.
He's cheating and
Robin?
he's
Overall, answer
ripping
the question,
away,
please.
Did you tell the government
ripping
about
off the
that?
I didn't
government.
have a retirement at that time when I first got out.
Okay. So when you got retirement
Hold
later,
it
then
on
you
the
became
table.
more ill or something?
Yes.
Okay.
That's when we pay for something
Are you working today?
No.
extra that doesn't show up on the books.
Mhm.
Yeah, but paying under the table is like if we have an agreement that you will sell me something for $500 because of taxes, and in reality you pay it for you sell it to me for 5,000. I'll pay you 4,500 under the table. So tax daddy doesn't see that.
I'd asked you earlier if you were in special ops or a sniper, I believe, correct?
Correct.
Okay. Do you ever represent anybody that you were?
Not that I'm aware of.
Okay. Let me show you your deposition. Page 8, line 25.
Yeah, he got pew 3 times in Afghanistan. I had some maps, noon delight.
Stop it.
My question again, did you ever make a representation to anybody that you were in special ops? Reading your deposition, does that refresh you?
It states that I didn't
Sir,
present
I asked you
myself.
that question. Does that refresh your recollection?
Actually, Your Honor, just trying to answer the question.
No, I asked him if that refreshed his
Please
recollection.
re-ask the question and please answer directly.
You read your answer, correct?
Correct. It
My
says I
question to
don't.
you is just this. Did that refresh your recollection whether or not you ever made that representation?
And I stated it says I didn't.
You represented, no, I said, no, question, no, I said to anybody, that I don't know. That I don't know, correct?
And I just
Were you going around telling people, Mr. Townsend, you've been special ops?
I was
That
not saying I
was
was
really
special ops.
pathetic.
Did you ever tell Laurie again that you'd protect her from Michael?
No.
That was really pathetic trying to like, gotcha.
You had discussed
No.
with Laurie about getting a divorce, correct?
I said me and my wife were in a bad spot and we had talked about a divorce.
Now, Laurie wouldn't be satisfied with that explanation, would you? She'd want a little more from you, correct?
Correct.
Okay. So you had to broach this topic, make some representation that you guys were going to be an item in some fashion, correct?
No.
Okay. Did Laurie was content with you saying, well, I'm going to stay with the wife. I'm just over here having some fun?
The agreement in the beginning was
Sir, is that what the relationship was?
Your Honor.
Well,
Stop.
Lori was content with
Over
sleeping
your
with a married
witnesses.
man. Jeez, oh Pete.
Yeah.
So
Again,
don't act like she's innocent in all this.
it's the same we saw yesterday. Whenever he gets flustered because he doesn't get the answers he thinks are in the deposition, he did it to the lead investigator. He just starts yelling at them and railroading him. It's kind of the same thing AJ did in the Karen Reed case when he needed something put in before the objection came, but he didn't do it constantly and with stupid takes like that. He did it when something was really important that he got in the mind of the jury. He'll talk over an answer when they didn't answer the way he liked it, and he knew an objection would be coming. But this is just an idiot yelling over another person to try and hide the answer that's coming out of his mouth. He's misrepresenting every answer he's given.
Just let him answer this question.
No, not the question when I'm asking you
Can
about.
we approach?
Come on up for sidebar, please. Thank you.
Yeah, better take a sidebar. He can't answer the question when I'm about to, because he's not answering the way I want it to be answered. And again, Jamie, you have you ever known a man or two where I know you're very young and you don't have that much life experience. Have you ever been to the
Yeah.
movies with a guy?
Yes.
Or maybe,
Mr. Townsend, you were describing the relationship you.
sorry, have you ever went out for a cup of coffee with a guy and he might have misrepresented something in his life? Maybe
Sure.
said his fish was a little bit bigger than 5 inches and stuff like that.
Yeah, sure.
That's not an indication that he unalived someone. It's such a stupid. I really don't like this guy.
Had with Laurie. You're having this affair with her, correct?
Correct.
Okay.
Nope.
Tell us about this relationship. What your understanding was with Laurie Shaver.
they're supposed to be friends with benefits, no strings attached.
Friends with benefits. Okay.
Okay.
So friends with benefits, you are legally married then.
And yet you're still contemplating a divorce at that time, correct?
Buddy, the friends with benefit, if you're contemplating a divorce, she's the one that gets you into that clear mindset. She's not the one you end up with. Another little trick for you ladies. If you catch him on the way out of a relationship, he's probably not going into one with you, but he's going to use you in that layover period.
But yeah, if you're going to be giving up, then why not?
Yeah.
They're going to be
Mama's
there.
with, yes, this is with JJJ.
Correct.
Okay, so there was a discussion.
A discussion about what?
Now, your position is you had no knowledge of Michael Shaver being shot, correct?
Correct.
Okay, you weren't in the house, correct?
Correct.
Now, you knew the Shaver children, correct?
I didn't know them, like, on a personal basis. I knew she had children. I only seen them a handful of times.
Okay. A handful of times. You're there 2-3 times a week. Okay.
The kids are in school.
Now, you're there at their Christmas break, correct?
The kids were not there. They're in school.
Okay. During their Christmas break.
I wasn't there during Christmas break.
He said that 10 minutes ago. I was there the first 2 weeks of December. Then the kids were on Christmas break and I was home with my family. I remember that testimony. Why can't you?
He's just trying to get him tripped up.
When was Michael shot?
I don't know that.
Okay. Did you ever make a statement indicating to the contrary? I'm going to show you your deposition again, sir.
And he probably said, I don't know, sometime in October. Oh, so
I know what I told you.
Okay.
Yes, sir.
Page 16. I want you to read line 3.
Yeah.
Through section 2. So.
He's just trying to trip him up so he looks like a liar.
Yeah. Yeah, Matt has it right. He keeps running into the same wall.
Yeah.
Finished?
Huh?
Okay.
Becca, I don't know if he believes her. He's being paid to believe her. So he has to do, and I know I shouldn't be yelling at him. He's just trying to do the best for his client. No matter how bad a client, they deserve a good defense attorney but this isn't one.
Your position was,
European.
I have no evidence that I was nowhere near during the time frame or whatever happened to Michael. So now you're saying, I don't know when he was shot, but I know I wasn't around there during that time frame.
So he didn't know.
So he didn't know.
Ah.
Correct? So you're saying, I don't know when this man shot, but you can't pin it on me.
But if you read farther, I said that.
Is that what you just said?
Your Honor, objection. I'm trying to answer the question.
No, you can rehabilitate your own witness.
All right, and Mr. Wiggs is correct. So please answer
You
the
can
question
rehabilitate
directly.
your own witness.
And once the question's asked, answer it directly, and then move on. Thank you.
Right? So you don't know when he was killed, but you're saying you can't pin it on me. I was nowhere around without knowledge when he was killed. Correct, sir? That's what you stated in your deposition.
No, it's not.
I just read it to you. You just read it yourself.
But like I said, if you read farther.
Sir, that's what you said, right?
Just let him.
If you take anything out of context, again, for all of us who had the Karen Reed case in reference, I hit him. It's being cut up by the Smurf all the time instead of playing the clip where you can clearly say, see, that's not what she's saying in the clip. You have to put it into context. And again, he said, I wasn't around at that time because he didn't know Michael. He never saw Michael. Ergo, it must have happened before or after. Jamie.
He wasn't around in that time frame, and to me that can mean I wasn't there. I don't know. Oh, so you're saying it was you knew the time frame? Okay.
Yeah.
So pull at the strings. Who cares?
Can we approach with the transcript?
Sidebar, please.
Oh. Well,
that's what he's got to do. He just wants to trip him up. That's it.
Upgrade from Brandy is Laurie Shaver appears to be crying. This is the first time the entire trial I've seen her cry. She's wiping tears with tissue. I hear sniffles. Hard to tell when it started, but it wasn't long after JJJ's comment about her just being a friends with benefit. No strings attached. Wiggs was about to ask Laurie if there was anything she wanted him to ask Jay. Now he's asking Jay about his tattoo. Oh, so we are a little behind, so we're going to get some gold about tattoos. Sorry.
Did the state advise you of a date that Michael Shaver was shot?
No.
Okay. One moment, please, Judge.
Yes, sir.
I mean, this is your guy, and this is all you got for him? This doesn't look so good, Mr. Wiggs.
No, this is the guy who did it.
Yeah, this is the guy who did it, and
Yeah.
it didn't go
You
very well
didn't
for
come
you.
into you didn't come into the room after the daughter missed him and then finished the job. You need to ask that question.
Yeah,
Mr.
that's
Townson,
what you said
did
happened.
you get a tattoo in 2016?
No, I did not.
Do you have any tattoos at all?
I do.
Would you describe them?
It's an Indian dress chief with a compass and a map,
Anything else?
roses.
You ever roses? Tell me about that one.
The roses are in the tattoo.
Okay, what's the full tattoo?
I just described it.
He
Pardon me,
just-
speak up.
I just described it.
You said it's roses in a tattoo. What's the full tattoo?
It's an Indian chief with a map and a compass.
Okay. Did you see Miss Shaver at the store in 2016? Approach her to show her your new tattoo.
No,
Okay. You never did that, correct? Okay. One moment, please.
Like, okay. Are you going to get people
Again,
to say
it's
that she did?
That would be like me. Mr. Townson, your family own any property in Silver Springs area?
No.
Okay. Do you have parents in Ocala?
no.
Okay. Do you have any parents in the state of Florida?
Yes, I do.
Where do they reside?
Crystal River.
Crystal River. Okay. They own any land?
That their house is on,
Yeah. How much land?
5 acres.
Okay. All right. That's all I have. Thank you, Judge.
All right, thank you. State?
So he buried him on that ground and moved him back. Is that where we're going now with the broken ribs? But just
I don't know.
to say how stupid it is, I have my tattoo here that you can't see because I have to speak into this microphone. I have this tattoo of a sailor and a plane. And if you say, what about some laurels? Yeah, there are laurels in the tattoo. I wouldn't describe the laurels normally. It's just a plane for my dad's service, my Navy service, and my 2 deployments. It's such a stupid argument. Describe the tattoo. It's in the tattoo. The laurels are in the tattoo. Yeah, describe them. It's not tattoos with her name in it, stupido.
Mm-hmm.
Get back to the whether or not you made a prior inconsistent statement about knowing when Michael Shaver was killed. Let me show you your deposition transcript, and can you just go ahead and
That's improper.
Oh, it's yours.
Sustained, please ask the question. If the question isn't asked properly, then you can approach the witness with the deposition. Please inquire.
did you in that
Let him
deposition
explain.
tell Mr. Wiggs
Let him
repeatedly that you do not know when Michael Shaver was killed?
Correct.
And that statement that Mr. Wiggs was reading about I have evidence that I was nowhere near during the time frame or whatever happened to Michael Shaver, did you say at least 4 times after that you did not know when he was shot?
Correct.
As far as September, your memory about when you first met Ms. Shaver at deposition, you said you didn't remember, and today you said that you first met her in the park in September of 2015. So what happened in between the deposition and today that helped with your memory?
Went back through all the old text messages to refresh my memory because this is 9 going on almost 10 years ago. I don't remember everything I did during that period of time. So to refresh myself, if I was asked that question, I would know how to answer it. So I went back through all the old text messages and figured out when I seen Ms. Shaver.
Nothing further, Judge.
All right, thank you, Mr. Wiggs.
Thank you, Judge.
Thank you. And may the witness be released from his subpoena.
Yes, sir.
All right, thank you for testifying today, sir. You're released from further testimony. Have a good day. Yes, sir.
What are they going to do now? 'Cause,
Please call your
I
next
mean,
witness.
State recalls Detective Jared Strickland.
That's like nothing. That was a nothing burger.
So the guy who did it wasn't asked. Well, he was asked shortly if he did it, but they didn't lay any foundation to prove he did it.
Yeah.
Good morning. Please come up to the witness stand. Please make yourself comfortable. Let me know when you're ready to proceed.
So they're just going to lay it all on the daughter now? Or what?
All set. Okay, please state and spell your full legal name.
Jared Strickland, Jarrod Std
Oh, it's the guy with the
R-I-C-K-L-A-N-D.
thick and
Please
pithy.
raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please proceed.
One moment. Got my monitor on.
That's the tech guy from yesterday.
Yeah. Yeah, he has no proof of anything, Marissa. It's just all Laurie's word.
Yeah. And again, claiming you were special forces doesn't make you special forces. Just ask Ace Ventura, not Ace Ventura, Jesse the Body Ventura. Well, he claimed he was a SEAL team. He wasn't. He was a demolitions expert.
No, I love the slip of Ace Ventura. That's
The daughter was 7 at the time, 15 or 16 now. We hear different
All right,
things.
Detective, can you just reintroduce yourself to the jury?
Sure. Good morning. Corporal Jared Strickland, the Lincoln Sheriff's Office.
All right. Now, going back, talking more about Facebook records that you analyzed.
Sure.
And just as a quick reminder, how many different IP addresses were shared with the Michael Shaver account and the Laurie Shaver account over that 2-year period that you analyzed?
There were 13 IP addresses between the two.
And looking at Laurie Shaver's Facebook records first, shortly after Mike Shaver's disappearance in November of 2015, was there record activity showing Laurie Shaver basically returning all?
Actually, no, Mom of 10, because the opening statement, he claimed that Jay threw them out of the house and buried the body. He never talked about that. His opening statement was Jay came in, he was sitting in a chair. The daughter had tried to, but didn't do it. Then Jay did it and threw them out of the house. Tell, I'm going to off you too if you don't get out. And when they came home, the body was gone.
yeah.
But they
And
never.
She just asked no questions.
Yeah. So
Didn't even touch on that.
he never asked those questions. He didn't prove his opening statements.
On Facebook or becoming active on Facebook again.
Yes, there was.
And specifically, what indicated that when you
There was a photo of her that was posted, a selfie that she took of herself. And the comments that were on that photo were essentially saying things like, welcome back, it's been a while, happy to see you back.
the state is showing defense what has been previously been marked by identification of states RR.
Yes, Nicola. Lally was just a repeat machine that was stupid. This guy is.
Witness states RR, Tragic 97.
Yes, I do.
And what is that exhibit?
This is a selfie photo of Laurie Shaver.
Is that the one that we just discussed?
Yes, it is.
And was that taken from the actual Laurie Shaver Facebook records that are already in evidence?
Yes, it was.
This time the statement states RR in evidence, it states 46.
They can object on 94-401 and the objections that's raised in a motion to exclude digital data.
He said he didn't meet her kids, as far as I understood. Well, thank you so much, Sonata number 8. It covered up my first mistake I got as a tattoo.
All right. Objections overruled. States RR will be entered into evidence of states number 46.
Go ahead and publish. What was the date of this selfie post and the comments about the back?
November 11th, 2015.
Now, on November 11th, 2015, did she make another post?
Yes, she did.
And what type of post was that?
It was a status update, so it was just basically words that she typed.
State is showing defense was previously been marked against states exhibit SS for identification. Showing the witness states SS. Is this the status that you referred to?
Yes, it is.
And is that taken from the Laurie Shaver Facebook records that are already in evidence?
Yes, it was.
The state would move states 40 SS in evidence to states 47.
Any objection?
Same objection, Judge.
All right, objections overruled. States SS will be admitted into evidence of states number 47.
Go ahead. And can you go ahead and read that status?
Of course. Sending a huge thank you for those who've served our country, my dad, grandfathers, and to my brave, loving man. Can't get any braver than those men and women. So much respect.
And as the course of the investigation, was there ever any indication that her husband, Michael Shaver, was in the military?
No.
Was there ever any indication that her boyfriend at this time, Jeremy Townson, was in the military?
Yes.
And what is the significance of November 11, 2015?
It's Veterans Day.
Over the next couple of months, did she post anything on Facebook regarding her workouts or physical activity?
Yes, she did.
Showing defense what has been previously marked for identification as states TT, UU, and BV. Showing witness states TT for identification. You recognize that post, TT
Yep.
specifically.
Yep.
What is that post?
The photo of Laurie Shaver on it looks like a weight bench.
And it was that from her Facebook records that were previously entered into evidence.
Yes, it was.
And states UU, what is that?
Also a selfie photo of Laurie Shaver in a vehicle wearing workout clothes.
And does it reference in the content of that going to have something to do with workout without reading what it is?
Yes, it does.
And what about states VV?
It's a photo of a workout machine in a barn or a shed.
Now, are all three of those from the Laurie Shaver Facebook records that we've been talking about previously in evidence?
Yes, it was.
At this time, Your Honor, the state removed states TT, evidence is 48, UU, and evidence is 49, and VV, and evidence is states 50.
Any objection? Objections are overruled. As to the three exhibits, states TT will be entered into evidence of states number 48, states UU will be entered into evidence of states number 49, and states VV will be entered into evidence of states number 50.
Very quickly, before we move on to publishing those photos, I do want to go back to the activity from November 11th, 2015. Based on review of the IP logs, was there any other activity other than posting photos or status updates associated with that date?
Yes.
And what was that?
Michael Shaver's activity also, I believe.
Was there anything on Laurie Shaver's IP logs that is already in evidence that refers to her changing her Facebook profile name?
Yes, her name was changed.
And I'm showing a page from the IP summary. Can you just step down and indicate to the jury where that is and tell them what page number that is on this from the summary?
So again, same as yesterday, month, date, IP address, activity on the Shaver account, activity on the, Mike Shaver account, Laurie Shaver account. On November 11th, 2015, the action on Laurie Shaver's account shows a name change.
And thank you very much. That was from you. Go ahead and have a seat.
I don't think
I'm going
YouTube
ahead and
can do that.
publishing states 47, previously marked as TT. Is this the workout picture that you referenced?
Yes.
And can you go ahead and read the post associated with that?
She and Michael had been high school sweethearts. They moved to Florida together, so it was a long time. But as you know, with fish, they need no.
Slowly getting back into the weights and was happy to see these muscles come back alive today. Smile through the pain.
Go ahead. 49. What was the status posted there?
Mentally preparing myself for leg day with the most awesome personal trainer. Not gonna lie, I'm a bit scared. It's a love-hate relationship. She makes me swear, LOL, and I don't do that often.
What date was that posted?
January 2nd, 2016.
And finally, the cable machine, when was that posted?
May 14th, 2016.
Also contained in the Laurie Shaver Facebook records was their photographs and other posts associated with her engagement to Travis Filmer.
Yes.
Was there also photographs associated with the ceremony that occurred on December 31st, 2016, between herself and Mr. Felmer.
Yes.
Showing the fence what has been previously been marked as states SSS for identification. Showing what it states SSS. You recognize that post.
Yes, I do.
And is that post from the Laurie Shaver Facebook records that's already in evidence?
Yes, it is.
Your Honor, this time the state moves states SSS into evidence at states number 51.
No objection, Judge.
All right, objections overruled. States SSS will be entered into evidence as states number 51.
Go ahead and publish. And first of all, can you read the date that this was posted?
August 12th, 2016.
And was there any sort of message that was associated with these photographs that were posted?
Yes, there was.
And what was that?
God has gifted us with a great blessing, that of bringing us together. We are excited to now publicly announce we are engaged. We have appreciated all the love and excitement from our close friends and family. We are so blessed. I'm going to be a filmer.
And what date was that?
I hate people who always have to put all about their relationship on social media. If you're that insecure in your relationship, don't spend time on Facebook telling everyone how cool your relationship is and how much you love the guy. Go love him instead.
I know.
That was August 12th, 2016.
There are also posts
Yeah, he saw the kids. I don't think he said he met them.
associated with the installation of the fire pit and ultimate cement slab.
Yes.
I'm showing you what has been previously been marked as states WW, show up to the fence. You recognize that post and series of photographs.
Yes, I do.
And were those taken from the Laurie Shaver Facebook records that are already in evidence?
Yes, it was.
Or at this time, the states moves states WW into evidence at states 52.
Any objection?
No objection, Judge.
Objections overruled. States WW will be admitted into evidence as states number 52.
Go ahead and publish the photos. First of all, can you say the date that this was posted?
March 24th, 2016.
And what is the content of the post?
Newest project. Built this fire pit today. Cut a portion of the fence for straight access from back porch, and now just need to pour in concrete. Put in a new gate and figure out seating. Going to be a great summer.
Her problem is straight access.
Now, the final photo from there, do you recognize the children in that?
Yes, I do.
And who are they?
Those are Mike and Laurie Shaver's children.
Thank you very much. She referenced pouring a concrete slab. Were there later posts on her Facebook profile about purchasing some concrete?
Yes, there was.
I'm going to go ahead and show you states XX, show the fence. You recognize this post from states XX?
Yes, I do.
Is that related to the purchase of concrete from Laurie Shaver's Facebook profile already in evidence?
Yes, it is.
At this time, the state moves states XX into evidence at states 53.
Any objection?
Same objection, Judge.
All right, sir. Objections overruled. States XX will be admitted into evidence as states number 53.
Go ahead and publish what date is this post?
April 28th, 2016.
And what is the content of the post?
It was originally a photo of bags of cement in the back of a truck.
Did Laurie Shaver comment on that?
There are comments, yes.
What did Laurie Shaver comment on that?
Yes.
Or what did she say?
Somebody asked what it was. She said cement. It's going in the area around the fire pit I built, going to make a seating area. Somebody else asked, how on earth would you mix and pour that? Don't you need?
I think special case behind. I'm thinking, what is she talking about? She's yelling about, oh my God, wigs and ass. And I'm thinking, he's not talking. I think you're a little behind. We'll see you when you catch up.
Need a huge machine? Good luck. Can't wait to see. Laurie Shaver, filmer, posted, nope, a wheelbarrow will do, and you mix with muscles. LMAO.
They rented a cement
In
mixer.
the course of your investigation, did you also find evidence of a subsequent purchase of more concrete,
Yes.
showing the defense what has been previously marked as states YY?
Why, oh, why?
Or at this time, the state moves states YY into evidence as with the appropriate business record certification and no intent to rely on such as states 54.
Any objection?
No objection.
Without objection, states YY will be admitted into evidence as states number 54.
Direct your attention. Well, first of all, what is states 54?
These are records that we obtained from Lowe's.
And is there a receipt showing the purchase of concrete by Laurie Shaver within those records?
Yes, there is.
And actually, can you step down and bring that with you if that'll help? First of all, can you indicate here on the receipt where it shows that this is connected with Laurie Shaver?
That's the customer name, Laurie L. Shaver in the top left.
Okay. And does it have a date that this transaction occurred?
It does.
And what is that?
September 12th, 2016.
And can you indicate on the receipt the concrete?
Sure. 42 bags of 80-pound crack-resistant concrete.
Thank you very much. Have a seat. Shortly after, well, associated with your search for records about purchase of concrete, did you also look into whether or not any cement-related equipment had been rented by either Laurie Shaver or Travis Filmer from any of the other home improvement stores?
Yes, I did.
And did you find any evidence?
I did.
And what was that?
There was a concrete mixer that was rented from Home Depot by Travis Filmer.
That's already evidence.
Mixer, baby.
Is there, after that cement mixer rental and this cement purchase, was there photos on
Around Christmas 15.
Facebook correlated with the cement slab around this time?
Yes.
I'm going to go ahead and show you what has been previously marked for identification as states ZZ. Showing when it states ZZ, do you recognize this exhibit?
Yes, I do.
And what is that, a post from Laurie Shaver's Facebook that we've been talking about already in evidence?
Yes, it is.
All right, this time the state moves states ZZ into evidence as states 55.
Any objection?
Same objection, Judge.
Objections overruled. States CZ will be entered into evidence as states number 55.
Publish. All right, first of all, what is the date of the series of photographs for this post?
September 19th, 2016.
And the second photograph here, what is being depicted in the photo itself?
The fire pit is visible behind the young girl.
And that ultimately is the cement slab that was covering Michael Shaver's body.
That's correct.
All right, I want to move on
That's so
to some
creepy.
discussion of the records from Michael Shaver's Facebook account again. Now this photo showing the installation of the cement slab, what date was that?
September 19th, 2016.
Did you find activity on Michael Shaver's Facebook after September 19th, 2016?
Yes, I did.
Showing defense. Sorry. Showing the witness was already in evidence. State's Exhibit 11. publish. What is State's Exhibit 11?
It's a photo of Mike Shaver.
And specifically, is this a photo from Michael Shaver's Facebook records?
Yes, it is.
And the what type of photo, what would Facebook categorize this photo as?
This was a profile picture.
What's the profile picture?
So with Facebook, you can post a photo that you want people to see whenever they either search for your name on Facebook or go to your profile. It's basically the photo that's front and center that people would see whenever they visit your page.
And when was this particular photo posted onto the Mike Shaver Facebook account?
March 8th, 2017.
So about
It's 2
6
years
months
after he passed
so it's
away.
about the Smiths line.
Or 6
Yes.
months. Oh,
Were there other profile pictures posted on Michael Shaver's Facebook profile after the cement slab was poured in September 2016?
Yes, there were.
I'm showing you what was identified as State's X. Entered into evidence in State's 12. Publish. When was that profile picture uploaded onto Michael Shaver's Facebook account?
January 2nd, 2018.
And when you viewed this picture, did it seem unusual?
It did.
And why was that?
It does not depict Michael Shaver anywhere in it.
So did you do any research into this photograph?
I did.
And what did you do? What did you utilize in order to research this photograph?
Sure. So I used what's called a reverse image search.
What is that?
So
thank you, Townson, for being a member for 5 months. But
Yeah.
updating his, let's see what the reverse image search shows.
anybody can do it. You can save an image to your computer, in this case, this image, and you go to Google and click on a little icon that looks like either a camera or a photo, and you can put that photo in to Google search, and Google will search all of the internet to see if that photo has ever been posted anywhere else.
And did you find indications of when and where this photo was posted?
Yes, I did.
And what was that?
This photo was posted on a Bloody Mary Mix company's Instagram page called, I believe it was Redneck Sportsman's Juice.
Now,
What?
the Facebook also have something referred to as a cover photo.
Yes, it does.
What is a cover photo?
Similar to a profile photo, the cover photo is like a large banner that's on top of somebody's Facebook profile page. It gives you more area that you can put stuff. Sometimes it can be words, it can basically be anything that you want it to be, but it's just a larger photo that can be posted on your profile page.
I'm showing this fence was been previously marked as State's BBB for identification. You recognize State's BBB.
Yes, I do.
Is that a cover photo taken from the Michael Shaver Facebook profile that is already in evidence?
Yes, it is.
Your Honor, this time the state would move State's BBB into evidence as State's number
56.
So she went in here and found a picture and put it on his Facebook to prove he was alive out having drinks. That's so stupid.
Sports bar.
That's Jamie.
Hey, she's trying.
She's yeah. I'm trying, Yana. I'm trying.
I'm trying here.
Yeah.
That's funny.
Witness stand.
Because
looks
yeah,
like
he wasn't
Walter's-
in the picture, but he just found a picture of a bar. That's
Yeah,
funny.
I have seen the picture. It's just a Bloody Mary standing, but it's just so stupid. That's you can reverse
Right.
Google everything now. It's
56.
Same objection, Judge.
All right, objections overruled, and that's V as in Victor.
BB.
I think it's to this is after he went away, and they just want to put it in there again, so the jury has it fresh in remembrance.
Bravo. Okay. All right. Objections overruled. States BBB will be entered into evidence as states number 56.
Published. What date was this cover photo published or published on the page?
November 14th, 2017.
So almost 2 years from his disappearance.
That's correct.
And can you step down? Did you look at the IP log history associated with Michael Shaver and Laurie Shaver's Facebook in and around the time that this was posted? Sure. All right. And what activity in and around the date and time of this cover photo posted was appeared on Michael Shaver's Facebook?
On November 14th, 2017, the IP addresses are the same. Mike Shaver's account was a login activity that was done at 15:58 coordinated time. Laurie Shaver's account on the same day at 15:59 universal coordinated time, and it was also a login.
So within 2 minutes of each other.
That's correct.
Yeah, stay there. Prior to Michael Shaver's disappearance, what was the general content of his Facebook posts?
Mike Shaver's Facebook activity was primarily focused on airplanes.
Did he post pictures of himself, his friends, airplanes, things related to that?
Yes.
And I'm going to ask you, have you ever had reference to something called a meme?
Yes.
And what is a meme?
A meme is typically an image. It has words that have been transposed on top of an image. It's usually designed to be either witty or funny. It can be any picture that anybody wants to take, and they usually become viral and start floating around the internet.
Now, prior to his disappearance in November 2015, did Michael Shaver's Facebook show a lot of meme posts?
Only one that I can recall.
And after his disappearance in November of 2015, did that change?
It did.
I'm showing that's what has been previously marked as states CCC for identification. Showing the witness states CCC for identification.
Hey, Penela.
I'm Jimmy. How y'all doing?
What is that?
The meme is posted to Mike Shaver's Facebook account.
And that's a basically one page from the 3,000 pages that's already in evidence. John, the state moves states CCC into evidence at stage 57.
Any objection?
Same objection, Judge.
Objections overruled. State CCC will be entered into evidence as states number 57.
Go ahead and publish. First of all, what was the date of this post?
January 5th, 2016.
And what is the content of the meme itself? What did it say?
Don't take a good woman for granted. Someday, someone will come along and appreciate what you did.
Now, did you look at the Facebook activity as far as the IP logs associated with Michael Shaver's Facebook and Laurie Shaver's Facebook for that day?
Yes, I did.
And does that appear on the summary page 9?
Yes, it does. Sorry.
And what was the activity related to this post on Michael Shaver's Facebook compared to Laurie Shaver's Facebook?
Mike Shaver's account uploaded a photo. Laurie Shaver's account uploaded a photo.
And what were the times of those?
Mike Shaver's was at 16:05 universal coordinated time. Laurie's was at 2:08 universal coordinated time.
But sharing the same IP address.
Correct.
State is showing defense what has been previously been marked as DDD. Showing witness states DDD. Do you recognize that exhibit?
Yes, I do.
And what is that exhibit?
Also a meme that was posted to Mike Shaver's Facebook account.
Is that from the same Facebook records that we've been talking about?
Yes, it is.
State move states DDD into evidence at stage 58.
Any objection?
Objection, Judge.
Right, objections overruled. States DDD will be admitted into evidence as states number 58.
When it was published, first of all, when was this posted?
January 18th, 2016.
And can you go ahead and just read the content of the meme itself?
Some people need to mind their own business. Hashtag your life.
Now, was there activity on the same IP address from Michael Shaver and Laurie Shaver's Facebook accounts on that day?
Yes, there was.
And can you go ahead and tell the jury, first of all, when the activity was on Michael Shaver's account?
Sure. January 18th, 2016, 3:35 universal coordinated time. The photo was uploaded. January 18th, 2016, 15:21 universal coordinated time. Photo was uploaded to Laurie Shaver's.
Very much. Now, switching back to Laurie Shaver's Facebook. What was the general, what types of things would be posted on Laurie Shaver's account?
She would publish photos and also memes.
Based on the sheer volume of the records, it's fair to say she put that account was posted to much more frequently.
That's correct.
And the large number of pictures of herself, family, kids, things of that nature.
Yes,
But did she also post memes quite often?
she did.
I'm showing you what's been previously been marked as states EEE, showing to the defense first. Showing witness states EEE, you recognize that?
I do.
And is that a post from the Laurie Shaver Facebook records that is already in evidence?
Yes, it is.
Regarding at this time, the state moves states 58 into evidence and states 59.
Same objection, Judge.
All right, so states E, over defense's objection, states EEE will be entered into evidence of states number 59.
Go ahead and publish. First of all, when was this posted?
January 8th, 2016.
And what is the content of the post itself?
The photos of some
Yes, Penilla, you missed the JJJ. The JJJ, some of the ladies got instantly a little too interested until they remembered, yes, the JJJ did sleep around a lot while married, while having kids. Then they came down, they relaxed a bit. The JJJ didn't unalive anyone, didn't know anyone being unalive, didn't help cover anything up. And the entire cross-examination was just Mr. Wicks yelling at him and misrepresenting what he said in previous depositions. And he never ever got onto the theory he had in opening statements that the JJJ did it because the daughter had tried but didn't do it right. So it was a big nothing burger because the JJJ couldn't say anything other than there was a little too easy access to Laurie. They met at a park and then they spent her lunch breaks. I think the young kids call it doing the horizontal mambo.
times you just have to turn around, give a little smile, throw the match, and burn that bridge.
Now, going down further on that same page, is there a reference to the next post?
There it is.
And what?
Why? He wasn't a big fella. She was working out. There was a pre-dog hole. It's not that hard. Put him on a top and drag him out there. You don't have to do it in 2 seconds. I can't see the problem. I'm pretty sure that if you put your legs in it, you could do it. If she's a CrossFitter, I don't know which gym it is. Little D knows what gym it is. If they have a CrossFit section, go in there and try to do a 200-pound sled pull. I'm pretty sure you could do that as well. You don't have to move him in one go. And if with grass and it's wet outside and he's in the top, it's not that big a problem. As long as you don't have to carry him, it's not that big of a problem. Just slide him over there. Anyone can do it.
What is the reference to the next?
Oh, yeah, and he asked if he had gotten her pregnant, if he was a special forces guy, if he lied about being on disability and getting paid by someone else. It was a mess.
Post that appears on that page.
Awesome day, getting dirty.
What date and time was that posted?
January 8th, 2016 at 0018 Universal Coordinated Time.
And on the following.
Yeah, there was a pre-dog hole because remember they have talked a lot about that dog pond he was building. That's why, because we've talked so much about it. And after yesterday, I thought about that hole must have been out there.
Page of the Facebook records, is there a photograph that's associated with that post?
Yes, there is.
I'm showing the defense what has been previously been marked states FFF for identification.
Or maybe I've done it too much.
You recognize states FFF for identification.
Yes, I do.
And what is that?
A photo of Laurie Shaver with mud on her shirt.
And is that the next page in the Facebook records that we've been discussing?
Yes, it is.
Or at this time, the state moves states FFF into evidence of states 60.
Any objection?
The same.
Objection
as
is
the
overruled.
counsel pointed.
States FFF will be admitted into evidence as states number 60.
Go ahead and publish. Now, during your review of the Facebook records of Michael Shaver, specifically referring to the photographs that were sent through Michael Shaver's Facebook account to Vanessa Townson, did you find evidence of photographs contained within there associated with this photo?
Yes, I did.
I'm showing the defense what has been previously been marked as states GGG for identification. Showing witness states GGG. Do you recognize those photographs?
Yes, I did.
And where were those photographs from?
These were from, I believe these were from Laurie's Facebook. Or these from Michael's Facebook and the images.
Are those from Michael Shaver's Facebook? The images sent to Vanessa Townson.
They are the images that were sent to Vanessa Townson.
All right, this time the statement states GGG and evidence that states 61.
Same objection.
Objections overruled. States GGG will be entered into evidence of states number 61.
I'll go ahead and publish. So the photographs on the left and right are from the photos sent to Vanessa Townson. The photo in the middle is the picture from Laurie Shaver's Facebook profile.
That's correct.
This is so
Returning to Michael Shaver's Facebook, as you were going through, other than that photo from the bar, were there other photos? Was there another photo that drew some suspicion from?
Yes, there was.
And I'm showing defense what has been previously been marked as states I. Showing witness states I. Is that the photo that you found suspicious from the Michael Shaver Facebook account?
Yes, it is.
All right, this time the statement states I into evidence that states number 62.
Any objection, Mr. Wiggs?
Same objection, Judge.
All right, objections overruled. States I will be admitted into evidence of states number 62.
Go ahead and publish. Is that the photo that we were referring to on the left-hand side?
Yes, it is.
And first of all, why was that suspicious to you?
It, like some of the others, also did not depict Michael Shaver.
And when you had your suspicions, what did you do to look into it?
A reverse Google image search.
And using the same process that you talked about from the bar photograph?
That's correct.
And what did you learn when you did that?
This photo is not original. It's been shared on the internet numerous times.
And when was this posted?
This post was July 25th, 2016.
And was there any other related information that you got from Facebook associated with this post?
Yes, there was.
And what is that?
This photo was uploaded along with a check-in location.
What is a check-in location?
So Facebook gives users the ability to let people know where they are. Whenever they go to the app, they can check in and basically tell people that they are at a specific location.
Now, do you actually have to physically be at that location in order to do a Facebook check?
You do not.
And was there information on the IP logs associated with this photograph and the summary?
Yes, there was.
And can you indicate, first of all, are referring to pages 53 and 54 of that summary?
July 25th, there's the IP address along with another IP address that was also used in the same time frame. Mike Shaver's account with a login, and then also an action photo uploaded.
And was there activity on Laurie Shaver's Facebook utilizing the same IP address?
Yes, there was a password change.
And what is the time, first of all, the time of the Michael Shaver Facebook profile associated with this check-in in the middle of Lake Okeechobee?
Sure. Mike Shaver's account was on 7/25/2016 at 13:10 Universal Coordinated Time. The password change on Laurie's account was the same date at 13:04 Universal Coordinated Time.
So within 6 minutes, both of these accounts are utilizing the same IP address.
That's correct.
Some of these trials would be ho-hum without Baker's funny side snides, which a lot of people don't get. Pay attention, please.
Right.
Oh, thank you, Mr. Meetup. And it's just really, really hard to find something to talk about or make fun of when we're just going through Facebook posts that we can't see.
Mhm.
And he didn't say where the last picture was, so I couldn't even Google that. We're just sitting here on this date, on that date, in this. Come along now.
We get it. She was posting.
We get it, yeah.
Same
She
time zone.
updated his yeah. I need some action.
Quarter to 11, I'd like to give the jurors a comfort break at this time. Okay, we're going to be in recess for 10 minutes. Thank you.
Even the judge recognized that they are so bored they need a comfort break. We've been going for 2 hours now. Opening were the start was just Proffer. Then we had with JJJ, which was quite okay because I could get mad at Mr. Wicks. But this testimony, do you need to go this far? We know she used the IP on 2 different accounts right at the same time, so we already know that. I would have gone with the redneck Booze company, whatever the name was, to show it was made up. I think kind of the big problem is they're doing what the state kind of have a tendency to do. I'll better show them more evidence so they'll believe me more.
Yeah.
And it's not working for me. And remember to do your kegels. It's very important part of town. We can do them while we're sitting here watching and doing nothing. Sing a song like the 90s icon you are, please. But I'm only 27 years old, so the oldest I can go is Oops, I Did It Again. That's Laurie's favorite song. No, it's Toxic. Toxic is her favorite song.
Mm-hmm.
I wasn't in Spandau Ballet. Was it right, said Fred? I'm too sexy for my shirt. Too sexy for my shirt. So sexy it hurts. And I'm too sexy for my pants. That's why I took them off, because I lost a bet. Yes, Emma, that's also what I like. Again, I've been doing this for 13 years in Denmark, and I've never ever had this stacking of. It's only the times where we sit and just turn off your brain and just stare at the end wall is if you have something like when they find, I don't know what to call it in English, but you know, when someone is fencing stuff, not this thing, but stolen goods you're selling, and you can find a warehouse full of stuff that you believe is from people fencing or stealing stuff. We have to go through each and every little part of it, because we have to figure out if it's 129 items you've tried to fence or 140 items. So we have to go through each and every one and have them read on the record, which is super boring. But normally we don't have all of this weird evidence. I'm in the middle of a case right now that it's not that pleasant, but the interrogation of the defendant took, I think, two hours, all in all. And that's all. The rest of the witnesses, we went through 8 witnesses Tuesday, and then we're gonna have some new witnesses Monday, and then it's done. And another thing, we don't have to waste all of. We're getting some professional witnesses Monday, and they'll just come in and say, "Yeah, I work at this and this institute." Okay, you know about that stuff then. We don't have to sit there and say, "But did you play real football or hand egg in junior high?" Oh, hand egg. Clearly not an expert. We don't have to waste all our time with that. We don't. I think you confuse the jury more. We can see it with the last interview Aiden did with the juror from the Kenry case. They totally didn't notice half of the evidence put in front of them because that's probably not important. And when the cops testified, that was probably cops are smarter than the rest of us. So it's Lally succeeded in what he was doing. He confused the jury to believe he had something.
Hmm.
No, I started in appropriate time, so I'm 27 today. Isn't it called fencing? Fencing stolen good? I'm pretty sure it's fencing. Fencing or hawking. That would be. I did it. Well, it's 2 years ago now. We had a case where a barn was. They raided a barn filled with, and they had stolen everything from batteries for screwdrivers up till Audis and most weird stuff. And they had to read it all into the record, and the prosecutor was sick, and it was the 22nd of December. Remember, in Denmark, we have the 24th is when we have Christmas, because we celebrated when Jesus was born, not like you Americans who do it the day after. No, we celebrate the Lord. It's just better that way. And on the 23rd, we have what's called Small Christmas Eve, and that's like a semi special day as well. But we had to spend the 21st and 22nd in court with a prosecutor who was like, item number 245635, a Makita radio. Geotag on the picture. That's a very long day listening to that poor lady. And that's why I said they should just be able to put it on a screen and run through it and said, has been testified to, and then we could go in the back room and look at it. I wish I could move like I did in the 70s or 80s. I missed that part of our interrogation. Oh, I know nothing. I went to Barbie's son at 10-year-old and can do a full runway walk with a 3-point turn. Is that like a child pageant? Barbie's son?
Well, like, is it like modeling? I thought it was in all like the teen magazines growing up.
I don't know.
And it was like a
No.
modeling agency.
No, don't give me the circle of something. We're live. Don't give me the. Don't go down now. Someone told me Jesus was born in the summer. It's probably Jamie. She didn't read the Bible. She also believes you shouldn't put cats in piñatas to ward off Satan.
You shouldn't.
Yeah.
Just why don't you not and see what happens?
Polish is they're probably Eastern Catholic. They don't call it Catholic, but it's probably the out of the Byzantium part of the Catholic Church, if they're Polish. Or maybe they could be Catholic as well, because they did send a priest down or Pope down there. You hawk your wares, you fence the stolen TV. Makita radio. Yeah, Makita has become a big thing, and the problem is all Makita looks alike. So whenever they go to somewhere and find what they believe is stolen goods, there's always a ton of Makita stuff laying around.
Okay, please bring in the jurors.
Oh, we're back, baby.
We're back.
I moved really well in the 70s. I won a race against 1.3. Yes. The Pope I grew up with, the one they tried to shoot. Can't remember his name now.
Oh.
Paul? No. Yeah. I don't know. Jamie is the Christian historic on this channel.
I guess so. I am not, guys. Sorry. Sorry to disappoint.
There's no proof of what month Jesus was born. We know Jesus born 6 to 4 BCE. He can't be born before the birth of Christ.
Please be seated.
Hello.
I see that all of the members of the jury have returned. Please proceed.
John Paul II, maybe?
Now, as you're going through Michael Shaver's Facebook profile and focusing on the messages and screenshots of text messages sent from Michael Shaver's Facebook to Vanessa Townson, did you find screen captures of text messages between Jeremy Townson and Laurie Shaver where they appeared to be in some sort of argument?
Yes, I did.
And going to go ahead and publish, go ahead and step down again. What was the time frame of these text messages?
February 23rd, 2016.
And taking that information, did you then look at the messages sent from the Michael Shaver Facebook account, the first message that was sent to Vanessa Townson, basically indicating that the person with that account wanted to speak with Vanessa?
Yes.
Going ahead and pulling up that portion of the records, when was that attempt to reach out to Vanessa done?
February 25th, 2016.
Going to go ahead and get away from Facebook now. We're going to move to financial records. Did you get, we talked about getting records for Laurie Shaver's.
They were supposed to be done yesterday. How can they waste this much time on nothing?
Bank accounts and checking accounts. Did you also obtain the information for Michael Shaver's bank accounts?
Yes, I did.
Showing you what's been previously marked. It states JJJ, any of those records?
Yes, they are.
All right, this time the state move states JJJ into evidence with the properly affixed notice of intent to rely on business records certification and business records cert showing the defense.
Judge, the same objection as to relevance, probative value, and authentication, as we say.
All right, the objections are overruled. Stage JJJ will be admitted into evidence of states number 63.
Now, what time frame of records were obtained?
Oh,
The records began summer of 2014 until March 2016.
Now, prior to his disappearance in November of 2015, what kind of activity appeared on his financial records, his bank records?
What I refer to as financial transactions indicative of normal everyday life.
What do you mean by that?
Physical locations in stores, retail establishments, restaurants, consistent paychecks, paying utilities and bills.
And the time frame that we have published here on pages 69 and 71 of the bank records,
wrong one.
What time frame are we talking about?
October 28th, 2015 through December 24th, 2015.
Now,
Nine.
after his basic time frame that he no-showed from work in November 10th of 2015, what types of transactions appear on those records?
The transactions are the purchases at least are no longer consistent with in-store purchases.
What types of transactions do we have?
Purchases online as well as ATM withdrawals.
And the ATM withdrawals, do they indicate where those were from?
We do.
And where were they?
Claremont and Disney.
Okay, so nothing from Georgia?
Nothing from Georgia.
And in other investigations, have you been able to go through and try to get video from ATMs and things of that nature?
Yes, I have.
Do they retain that video forever?
They do not.
So when this case came to their attention, had video from ATMs expired due to the 3 years that it had been before the body was even discovered?
Yes, ATM video is typically only held between 30 and 90 days.
And the online purchases, what were those?
There were 2 online purchases to wish.com.
What is that?
Wish.com is a kind of an alternative to Amazon. It's another online e-commerce.
It's not an alternative to Amazon.
Are they a little more difficult to deal with than Amazon?
They are.
All right. And what was the other online purchase?
The other online purchases were for Walmart.com.
Are there any deposits associated with this?
There is.
And what was that?
On December 14th, there was an ATM check deposit at the Citrus Tower Boulevard, assuming Chase in Claremont, for $2,539.
And that amount, is that consistent with other financial records that were obtained in this case?
Yes, it was.
And what was that?
We received a copy of this check from Mariner Finance, payable to Michael Shaver for $2,539.
And is that the same check that is referenced there in states 29?
Yes, it is.
Did you do, after that check was deposited, what were the next transactions? And just go ahead and read the dates and what they were and the amounts.
The check was deposited on December 14th. On posting date December 14th, there was a $100 withdrawal in Disney. On December 14th, there was a $200 cash withdrawal from the Citrus Tower in Claremont. On December 18th, there was another ATM withdrawal for $500, also from Citrus Tower Boulevard in Claremont. On December 21st, there was a withdrawal in Groveland for $400. On December 21st, an ATM withdrawal for $500 from Citrus Tower. And then on December 23rd, another ATM withdrawal from Citrus Tower for $500.
Now, moving on to page 71, is this the page that references the transaction with Walmart.com?
Yes, it is.
And can you go ahead and just point to it and say the date and what that transaction was?
December 23rd, card purchase. The transaction date that's listed in the description of the transaction is the 22nd. Walmart.com, $397.16.
And did you do research into, with Walmart, into the source of, or basically what was purchased and where that was sent?
Yes, I did.
I'm showing you what's been previously been marked as states, well, showing defense was previously marked as states LLL for identification. Showing the witness states LLL for identification. Do you recognize that document?
Yes, I do.
And are those the records that you received from Walmart?
Yes, they are.
All right, this time the state moves states LLL in as a business record with the valid notice of intent to rely on business record certification, along with the valid business record affidavit.
Any objection?
Judge, same objection. Standing.
Objections overruled. States LLL will be admitted into evidence. States number 64.
Now, included with that exhibit, do you have the is there the printout from Walmart along with the disc?
Yes, there is.
And this information that you received from Walmart, did it come to you electronically?
Yes, it did.
And is it easier to read the original electronic PDF as opposed to the version that is printed out?
Yes, it is.
All right, this time out of public.
Yes, sir.
Go ahead and use the CD.
Oh my God, stop it.
Now there's two documents on this CD. I'll pull up first one first.
No, the state hasn't rested. We are just wasting hours of time going through financial and digital records. So now we are sitting here listing what movies were in the theaters in your birth year and what the top billboards won the top 100. Mine was Titanic and Candle in the Wind.
Oh my God, stop it.
So please try to remember what was on your birth year.
While this is pulling up, you go ahead and go into the bank records, the areas with the Walmart transaction.
Yes, and for those wondering, hot in here was the top 100, number one, the year Jamie was born.
What year is that?
When you're 22 years old.
Oh, 22. God, to be 22 again. Ugh.
So as we go on here, what information is contained in this first page of records?
This is the order summary for the Walmart purchase that was made.
Right. And first of all, who is showing from the Walmart records as the purchaser?
Laurie Shaver.
And where does it show that this purchase was delivered? Is that on this page?
Right here, as well as right here.
And up here at the bottom, what is indicated here as far as the actual purchase itself?
These are the purchase amounts, as well as the date and time.
And is the purchase amount located on the bottom here consistent with what was from the Mike Shaver Facebook records?
Yes, it is.
I'm sorry, Facebook records, the bank records. And that also indicates the how it was paid?
Yes.
And is that associated with his credit card?
Correct.
Going on to the
Jamie, you're so young that the second Harry Potter movie came out the year you were born.
That is amazing.
But it's the same year Austin Powers and Goldmember came out too, and that carries
What's your
my
favorite?
life lessons. I hate intolerant people and the Dutch. I love the Dutch. Hey Helen. Hey Russian.
other pages include billing information, other things associated with the Walmart.com transactions.
Yes, it is.
And once again, who is shown as the purchaser?
Laurie Shaver.
records include information about other purchases?
These are the items that were purchased.
And what was the types of items that were purchased?
From looking at them with the close proximity to Christmas, I believe that they were Christmas gifts.
I make love to you.
Looking at Michael Shaver's bank records, was there any activity whatsoever past December 15th, 2015?
No, there was not.
Your Honor, the state has no further questions at this time.
All right, Mr. Wicks.
Mr. Strickland, or Officer Strickland, all the data that you introduced, all of it that's been discussed so far, does any of it mention homicide?
I will repeat what I said yesterday. When
That's a yes or a no. Does it mention a homicide?
the word homicide is not appear in those records.
Correct. Okay. Does any of the records that you've introduced, do they discuss aiding and assisting somebody from being detected?
To repeat what I said yesterday,
Do they mention anything about preventing somebody from being detected?
not as you quoted.
Correct. Okay. Now, you've spoken about financial records. You've shown photographs of Laurie with blood on it, correct?
With what?
Blood on a shirt or so?
Yes.
Okay. Did you go through the financial records, for instance, and link that up for any particular
Don't
purpose?
ask those stupid
Which
questions
part?
again.
Well, the mud on the shirt.
Yes, I did.
Okay. What's the mud represent?
The mud was the day that her and Jeremy went to Revolution Off-Road on State Road 33 in Groveland.
Did you suggest that to the jury? Direct examination?
There were purchases made.
Did you suggest that on direct examination?
That wasn't asked.
Right, that wasn't asked. Okay.
Why didn't you say the stuff that I want you to say during direct examination? Because I wasn't asked to do it. But did you say it? No, because I wasn't asked. For a guy who famously have 100 cases, I think that's this guy or is Sarah Boone's guy. I can't remember.
No, Sarah Boone's guy.
Oh, sorry. For a guy who famously has pants with small icons on it, he doesn't know much about testimony.
That, in fact, was not any implication that she had dug a grave or buried Michael Shaver, correct?
No, sir.
Now, you talked about or you showed images of Laurie working out. Okay. Any of the Facebook data that you look at indicate her being involved with Beachbody sales?
I have no idea what that is.
Okay. Any of it indicate, did you look through each and every document indicating why she may be working out?
It's like she enjoyed it.
Yeah, a lot of people like to work out. Correct. Doesn't suggest necessarily they're planning a homicide, does it?
To repeat what I said yesterday,
Sure. Does it necessarily imply somebody's planning a murder?
no, it does not.
Okay.
Okay.
You talked about this Facebook account being accessed and that Facebook account and it being Laurie and Michael's, correct?
Yes.
Okay. More than one person could have accessed that account, correct?
Sure.
More than Laurie Shaver, correct?
Sure.
If anybody was in the house, Jeremy Townson, you know, he testified he would be in the house, he may have been able to access those accounts, correct?
Theoretically.
And there's been no link up testimony between the IP, the physical residence, and any device, correct?
Incorrect.
Okay. Didn't you testify yesterday that these IP addresses expire over time? Was that?
Not that they expire every time. No, my testimony yesterday is that those records were only held by CenturyLink for a rolling 12 months.
And that there's no preservation of the IP address after a period of time,
Not for CenturyLink.
correct? Facebook, did they internally keep the IP addresses
They do.
in perpetuity?
They do.
Okay. Do any of the records that you've spoken about show causation of a homicide?
To repeat what I said yesterday.
Sir, I'm not asking you to repeat what you said yesterday. Do any of
Then don't ask questions that you already know the answer to from yesterday, you other moron.
show and reveal causation of a homicide?
Define causation.
The manner of.
Those records did not know.
You mentioned about banking records. Laurie Shaver's not on trial for bank fraud or any such charge like that, is she?
No, she's not.
You mentioned memes that were posted, correct?
I did.
And one was introduced and it said, I think something like, sometimes you have to burn the house down and move on.
The
Correct?
bridge.
Have a great night, Unbossed Aussie, and thank you for listening in bed. We like to get in bed with you. Oh my.
Night, Laura.
Oh my.
Giggity, giggity, giggity.
I could get and move on. Okay. That's an
Thank you. Yeah, I could be a little bit like Superman.
expression, correct?
It is.
Finding a bridge burnt down or anything like that that was relevant?
An actual literal bridge, sir? No, sir, I did not.
Wait, what? Wait, what? An actual literal bridge? No, I did not. What did he ask?
You
Hang on, go
mentioned
back.
memes that were posted, correct?
I did.
And one was introduced and it said, I think something like, sometimes you have to burn the house down and move on.
The bridge.
Correct? Okay, and move on. Okay. That's an expression, correct?
It is.
Finding a bridge burnt down or anything like that that was relevant?
An actual literal bridge, sir? No, sir, I did not.
Sorry, I just felt like, what is he asking? Oh, Lord.
This is like Sarah Boone when she put in writing, curious cat meme. That's so stupid.
It's just so stupid. You didn't find no bridges literally burned down, sir, did you? What?
Yeah, it's a meme.
Oh, man.
And these memes that you've testified to or have been presented are just standard phraseology, correct? This isn't a personal thing somebody's created necessarily.
Well, they can be.
Okay. Do you know who created these?
I do not. I didn't look into that.
Okay. You do these searches where you can look at photos and see if they're posted anywhere else.
Sure.
You know if Laurie Shaver created that meme, any single meme?
I do not.
Correct. And going back to all the records that you've spoken about that have been just ushered into evidence at this stage, you're unable to account for any specific number of images to say, this definitely came from Laurie, this came from this person, this came from this person, correct?
I don't believe so.
One moment, please, Judge.
Yes, sir. Thank you. Redirect.
When you're referencing Facebook maintaining IP records in perpetuity, is that how you were able to get the information
Hello, Iron Rapid. So good to see you.
from Facebook and create, and where that summary was created from?
That's where those records came from. I have no idea what their retention period is.
And then,
Happy birthday, Iron Rabbit. If it was your birthday yesterday.
so for at least the period of time that you asked for, they were able to give you the IP addresses associated with all of those posts.
Yes, they were.
And now CenturyLink and who would be the one that might know or would know who the physical address was attached to those different IP addresses, they have nothing to do with Facebook and vice versa. They're separate entities.
That is correct.
Nothing further to it.
Okay. Just on this IP issue, just for clarity, Facebook may hold the IP, but that IP is not linkable to a physical address over time.
Protection.
Not with the Facebook.
Pardon me?
Overruled. You may answer.
Not with the Facebook records.
Correct.
Nothing further to it.
All right. And may the witness be released from his subpoena.
He is subject to recall, but he can step down today.
All right, sir. You may step down from the witness stand. If you're subject to recall, please be available. Thank you, sir. Okay. And your next witness.
All right, at this time, the state of Florida rested its case against Laurie Shaver.
All right.
Oh,
Deputy, please take the jurors out. Thank you.
all right.
So, we're rested.
They rested.
So now we're going to have the motion, and then we're going on lunch break, and then the defense will start.
Okay. What does everybody really think, though? I mean, do you
What
really
everyone
think they
really
beat their
thinks.
case?
Do I have a poll up?
Well, now that they've rested officially after all of this.
Oh, I'm gonna end this poll, and then I'm gonna forget that I make a new one. If is a friend with benefit agreement the same as you have left your wife? 57% says no. Just rattling las lalas de tunas, 31%, and 10% says yes. Those 10%, my DMs are open if you're female.
Stop it.
We had discussed previously circumstantial evidence and any
I shouldn't say stuff like that because people will use it against me at some point.
We had cited to the court previously Smith versus Carlisle.
I do not want anyone in my DMs about anything like that. I disavow. No, thank you. I say stupid stuff enough on YouTube, and apparently right now someone is going around saying I support the Hales. I don't know anything about that stupid case. I just know all my friends are covering it. I don't touch it, but apparently I'm following or helping someone.
You're helping
least
someone,
lie.
yeah.
Yeah. If you want to lie about me, just keep the lie going. Then me and Jamie are lovers or something like that.
Yeah, what is that? Yeah.
Yeah, that we are married.
Yeah, that we're married, but we live in different countries. Yeah.
Yeah. Well, it is kind of like a marriage. She yells and I don't get any.
Yeah.
That decision is cited at 378 Southern 3rd, 1213. It's a 5th DCA decision quoting extensive language on history of stacking inferences. What I announced for the court previously is the history of stacking inferences started with Knight. It was further represented in Sims and Law and numerous other cases. And back in earlier era, that when those cases were effective, the law declared that the state could not rely on stacking inferences of guilt to try to reach an ultimate decision on the state's behalf. Later in Carlisle, Smith versus Carlisle, that decision did away with that same principle. And it stated that stacking inferences was permissible at this day and age. But what it did is it went back to an earlier principle, which is the Volcker decision, and that's cited at 70 Southern 2nd 403. And that is a Supreme Court of Florida decision, 1954. And what Smith stated was, citing from Volcker, which recited the criminal principle at that stage. It states that stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence. And the court went on to say, well, what the criminal rule is. And it says, only if the prior or basic inference is established to the exclusion of any other reasonable theory, then you may stack inferences upon another. I've repeatedly approached the bench, to the annoyance of probably everybody, observing and within the court to preserve this issue for an appeal, and declared that there's no basic inference that the state has at any time stated in this courtroom that they're going to try to declare.
According to some people on the internet, yes, Jamie and I are married. I just put on this fake accent, apparently.
Declare all the other inferences dependent and stackable, so to speak. So I've raised that and preserved it through this trial. At no time has the state announced any primary basic inference not subject to reasonable dispute. Without that basic inference, then stacking inferences becomes impermissible under the law. And the Volcker decision supports that principle. That would be one of the grounds for exclusion. Second, without stacking, with impermissible stacking, the state has never established causation. They have established that there's a dead body. They haven't established that Laurie Shaver is responsible for the dead body. They allege that we have a body and there's been some form of a cover-up. Now, the state again relies on circumstantial evidence and trying to stack inferences without a primary inference to rely on to declare that the crime was committed and it has to be associated with Laurie Shaver.
Jamie, we can agree on this one. We are friends with benefits. I have the benefit of knowing you, and you have the benefit of always being able to yell at me. Let's keep it like that.
To the exclusion of the rest of the world. We know there's been inconsistent testimony on that point. There's been acknowledgement by the state's own witnesses that devices can be hacked. They can be accessed by other people within a remote vicinity or within the access of the router. And it doesn't exclusively declare that Laurie Shaver thus is reliable for any homicide. The next thing the state attempted to do was to say, here's a body on the ground in a grave. And yet there's no evidence in any form or manner that ties to Laurie Shaver. So the only thing they're doing is trying to use a bunch of unsupportable inferences from the digital data, which isn't linkable. It doesn't make any mention of a death, a homicide, or a cover-up, to say simply you could have a motive and you may have committed a crime. That's insufficient evidence under the law. But we know as well, when we look at the physical scene, be it the gravesite, there's no DNA, there's no signature of a crime, there's no prints, there's no forensic data or evidence of any kind. We know there's no connective link between the grave and the home site. There's nothing found within the home site.
There was blood found in the home site, and it is connected because it's 12 feet outside of the home. It's on the same property. Come on now. If you're going to BS, so it doesn't smell.
Suggests Laurie Shaver transported the body, committed the homicide, or responsible in any manner whatsoever. So the state has failed to establish circumstantially and forensically that Laurie Shaver is responsible for the crime. We've moved judge for a judgment of acquittal based on those grounds. State that the state is not supported. The state has not supplied a case with competent substantial evidence for the matter to proceed forward to a jury. On those bases, we'd ask that request.
Thank you. State?
Your Honor, Mr. Wiggs is misinterpreting the case he's citing as far as Smith v. Carlisle. Once again, this is a civil case. Smith v. Carlisle states specifically, as it refers to the prior Volcker decision that Mr. Wiggs also is relying on, and this whole stacking one inference upon another, which Mr. Wiggs' argument relies. In the Smith case, it specifically says, the standard of review in entirely circumstantial criminal cases has now been discarded by the Supreme Court, which accurately described the rule as confusing and an outlier in federal and state courts. See Bush v. State, 295 Southern 3rd. It goes on to say, in Bush, the court upheld a death sentence based entirely on circumstantial evidence, and goes on to describe how the Florida Supreme Court is going away from from the previous decisions in Knight and the other cases of which Mr. Wiggs' argument relies on. It says, and the Supreme Court in Bush relied on the United States Supreme Court rationale in Holland v. United States in order to come to that conclusion. This is a quote from the Supreme Court's decision in Holland. Circumstantial evidence is intrinsically no different from testimonial evidence. Admittedly, circumstantial evidence may in some cases point to a wholly incorrect result, yet this is equally true of testimonial evidence. In both instances, a jury is asked to weigh the chances that the evidence correctly points to guilt against the possibility of inaccuracy or ambiguous inference. In both, the jury must use its experience with people and events in weighing the probabilities. If the jury is convinced beyond reasonable doubt, we can require no more. The Smith v. Carlisle case talks about how the court eliminated the special instruction regarding the circumstantial evidence case, and the Smith v. Carlisle case concludes by saying that it would also defy reason to hold that a person can be sentenced to the ultimate penalty under the law of death based solely on circumstantial evidence that does not exclude every reasonable hypothesis of innocence, but a plaintiff cannot survive a motion for summary judgment in a civil case based on circumstantial evidence alone. It goes on to basically say that this current civil standard makes no sense in light of the Florida Supreme Court's criminal standard in Bush, but says that for it to be ultimately resolved in a civil context, the Florida Supreme Court will have to weigh in on whether or not Volcker still stands in a civil setting. Smith v. Carlisle and Volcker have absolutely nothing to do with this court's analysis whatsoever, and the Smith case says that. What matters is what the Florida Supreme Court said in Bush v. State 295 Southern 3rd 179 in May of 2020, where it said because this special standard, and this is talking about the overcoming all reasonable hypothesis of innocence, because this special standard is unwarranted, confusing, and out of sync with both the jury instructions currently used in this state and the approach to appellate review used by the vast majority of the courts in this country, we discontinue its use. The Bush case, and I do have copies of Bush as well as Smith v. Carlisle, for your honor. Can I approach?
Yes, sir. Come on up. Thank you.
I can't do that. I don't understand Czech.
Quotes the same United States Supreme Court decision in Holland, which supports that there needs to be no special review by the judge in circumstantial evidence cases to determine whether or not all reasonable hypotheses of innocence have been overcome. This stacking inferences upon another is not the standard whatsoever. We have presented, despite Mr. Wiggs's assertions, we have absolutely shown evidence of causation. The cause and manner of death was established as gunshot wound, and the fact that the manner of death was homicide. The circumstantial evidence in this case shows that Ms. Shaver was the only person with the means, motive, opportunity to carry this out. She is the fact that the body was buried in her backyard shows that this was, as Detective Cameron Dale stated, not some robbery on I-4. The various evidence presented through bank records, Facebook records, phone records has established that Ms. Shaver has actively prevented the discovery of this body for years. Posed as Michael Shaver, used his bank accounts, used his phone, changed his phone number in order to try to manipulate Vanessa Townson, changed that phone number again to a phone number associated with her. She's had access to his Facebook, access to his phone, access to his bank, actively covered up his death, lied about it to friends, family members, and law enforcement. She has a firearm that is consistent with all class characteristics and as caliber as the projectile found in the skull. The state has presented more than enough evidence for this to go to the jury.
All right, anything further? Yes, sir.
No, Judge. Opposing counsel has this wrong. He miscites the Bush case. The case I cited, Smith versus Carlisle, is subsequent to Bush. It talks about Bush and what it was, and it talks about that Volcker was a civil case, but it indulged the analysis from a criminal perspective. And that's the very language it says. Stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test. So here's the new test. Because Bush did away with stacking inferences, it goes back to the former test, which is Volcker. And it says, only if, referring to the criminal standard, they say, only if the prior or basic inference is established, there's no been basic inferences established here at this trial, to the exclusion of any other reasonable theory. Okay, that's what it says. So counsel can say, well, that's a civil case, but it's quoting a criminal standard all through it. I submit these cases to the court.
Please approach.
The state takes a posture that somebody buried in a yard must have been the closest body to it, must have killed the person. Okay? You know, Jeremy Townson was at the residence from his own testimony. There's no such standard by proximity equals knowledge, equals
But you
homicide.
didn't prove that he was
There's no
there that
cases.
day or that time frame.
Well, you can't stack
That's-
inferences against Laurie, but you can stack all the inferences that doesn't point to Jay. That's what Branch versus Bush says. You can't use that against my client, but you can use it against someone that no one else can see did it. That's the legal term, Jamie. That's
Well, that's just annoying because it's like he was there. You didn't show that though. In any of the questioning that you did to him, you didn't show us that he was there in that time frame. That he had opportunity.
But Jamie, all of that showing that she had means, motive, opportunity, you can't use that against her. But not having means, motive, or opportunity, you can clearly use against him.
Yeah.
That's a big important takeaway. Hey, Vice's Raiders, we are just going through the motion to dismiss from the defense. The state have rested in the Laurie Shaver case, the lady who allegedly pew-pewed her husband in the back of her head, buried him in a dog pond, built a fire pit on top of his body, and who was more promiscuous than a sailor on shore leave.
Jesus.
Well, she is, Jamie. She hooked up with a guy she met in the park while their kids were playing.
And a guy that she met at a car dealership.
Yeah, and a guy she met at a car dealership. And a guy she met at the gym.
Yeah.
So
See, you can meet people out in the real world. Look at that. That's all you gotta do.
exactly. You don't need to go to the DMV. Oh, look who snuck in here. Talking about hooking up. Hey, little D.
Hi, Danielle. Yeah.
Going to be supportive of the theory that the state would advance here today. Likewise, all the physical evidence, each and every piece of it, does not implicate Laurie Shaver.
We haven't heard she slept with any of those, but she's snuggling up very close to her lawyer, and he made a video begging for money where maybe he takes a little bit, 10% in La Lala's de Tuna.
Shaver. I submitted to the court a proposed jury instruction. That decision was Bowen. And I submitted to your offer to the state as well. And it says knowledge of a crime, even if you know a crime's committed, doesn't mean you have to report the crime. The state takes a different posture here at this motion hearing and states that due to the fact she didn't report it, due to the fact that she covered it up and may have misrepresented it, she must be the person that committed the crime. Well, that's contrary to the laws I've supplied to this court in the Bowen decision, and the state can't contradict that.
Thank you, John Gary, for gifting 5 memberships to Charlene, Carlene, Great Central Crafting, Matilda, Debbie Webb, Becky R., and Nurse Kimberly from Kansas. She lives next to Dorothy.
The state can't contradict the fact that there's no forensic evidence, no ballistics, nothing to paint the picture that only Laurie Shaver committed this crime to the exclusion of the rest of the world. A reasonable doubt exists in a multitude of different fashions, as has arisen in this case, and it is not sufficient on these facts to submit the matter to the jury. Thank you, Judge.
Thank you, sir. All right. When viewed in a light most favorable to the state, the evidence does establish a prima facie case sufficient to support a conviction as to each count and the information. The motion is respectfully denied.
Thank you, Judge.
Thank you.
Short and sweet.
All right. And
Yeah.
Mr. Wiggs, does your client intend to testify?
I won't know at this stage, but shortly. Okay.
Okay. And how many witnesses do you intend to call?
Well, we would have fingerprint.
Yes, sir.
Are they gonna call the daughter?
So he doesn't know if she's going to testify at this point. And witnesses to call, we know the daughter is on the witness list.
And he said he was
And-
gonna call her, but now I feel like he's not.
Yeah, because again,
Well, that's
for those of you who came over from the Rises raid who haven't followed this, she blames her 7-year-old daughter for having pew-pewed her husband. And she also blames her 7-year-old daughter for not having done it, but her booty call, Jay, who she got a tattoo in the fun box area with his name in it, was the one who did it. Jay was on the stand earlier today, and he did no such thing according to him, and no evidence links him to doing it. He wasn't even around at the time.
Yeah.
But to begin with, she claimed Jay did it because he he was special forces and might have been a Secret Service agent for Bush. In reality, he was deployed to Afghanistan, caught 3 bullets, and is a disabled veteran now. Thank you for your service, Mr. J. Even the service that made you bedazzle La Lalas de Tuna. But opening statements was the daughter and Jay did it somehow in connection because the daughter missed and then Jay did it. And then Jay threatened to unalive everyone and buried the body in the backyard. And she never ever told anyone, even though Jay broke up with her right after that, which could be a perfect time to say, well, he did it. I was just afraid to say it at the time, but nah. The body wasn't found until 2 years later when the police was doing a welfare check and she was letting them into the house when they asked, hey, can we look at that concrete slab you have in the backyard? And she said, nah. And then they found him 3 feet under that concrete.
All right, Ms. Filmer, formerly Ms. Shaver, are you satisfied with the services that your attorney has rendered so far? Okay. Is there anything else that you would like your attorney to do in his representation of you?
There are no witnesses.
Okay, just into the microphone, if you could, a little louder so we can, please turn it. So
no witnesses?
Thank you.
No, I'm satisfied up to this point, yes.
Okay. Are there any other witnesses that you would like your attorney to call other than what you plan to call this afternoon, other than who you plan to call this afternoon?
So they will have
No, I don't believe so.
Okay. All right. Are there any other concerns that you would like to voice at this point? Okay. And you are completely satisfied with the services that Mr. Wiggs has rendered thus far. Is that correct?
Yes, Your Honor.
Okay. Thank you. All right. And we'll call the jurors back in and let them know that we're going to break for lunch. It's 11:45. We'll ask them to return at 1 p.m. All right. Is that agreeable with everyone? Okay. Please call the jurors back in.
Yeah, it looks like she got her hair done since yesterday. It's not as big as it was yesterday either.
Oh, she definitely lightened her hair up.
Yeah. Maybe she put in a little sun out and she was watching Jamie's Beauty on a budget every Sunday at noon. Beginning.
Never.
Jamie will be going over beauty products on the cheap at the dollar store, on a general and other stuff like that. She will bring on honorable guests where they will talk about best lips tips for thick, that's and cheese department. How to shave your ass, that's
What?
Ralphie.
Okay.
Yeah, Ralphie has donkeys.
All right, please be seated. I see that all of the members of the jury have returned, and thank you for your time and patience today. It is now 11:45. We're going to break for lunch. So it asks that you all return to the jury assembly room by 1 p.m. Okay, all right. Well, have a good lunch, and we'll see you back at 1 o'clock. Thank you.
To me, it sounds like I know the daughter is on the list.
He said he has a tech guy.
Yeah, they were talking about a tech guy, but I don't know.
Yeah.
All right. Is there anything further before we break for lunch? Okay. Please return at 1:15. Thank you. We're in recess.
1:15. So 1.5 hours break. Gabby, singing Barbie Girl is only for my more fun. This is a serious stream. Jamie, Mary Murphy, you have a request. You have to do a eyelash video.
I get them done, so I don't.
Jamie has a lady doing them for her.
Speaking of, it's eyelash day.
Whoop,
So
whoop.
exciting. So if they don't get done in time today, I have to peace out.
Well, we'll have Marissa call court.
Tell him to cut it early today.
Hey, Defense Rest, what's for lunch? Today I will be having. I actually don't know. I think I have something in the freezer. I'll have to check it out. Jamie should start doing prison beauty hacks. Have former convicts on to give her the beauty routines. Could be a thing.
I watched some of them on TV, and they're very crafty. How they figure out how to do stuff.
Let's just turn that down. Yeah, they're going to call Mark Zuckerberg and testify about IP addresses. Yeah, it's normally 1.5 hour lunches, which is pretty good because I don't think many courthouses has somewhere where you can buy stuff to eat, so they have to get out, get in. When I do jury duty, sometimes because the judge has his lunch with him in the courthouse, and he says, well, we're going to do it fast today, 45 minutes, and then I have to run out, find something to eat in a store. Luckily, there are 2 convenience stores right next to the courthouse. So, but then get out there, get back, eat your dinner. It's a little rushed sometimes, and
Yeah.
as a big guy, I need my lunch. Is it working today, Jamie?
I hope so.
How to shave your ass on a budget doesn't have quite the same ring. Well, Ralphie, you are an expert. She's going to testify if she changed her hair. It's go time. Raul, from your lips to God's ears.
All right.
Only Bev cut lunches into 45 minutes in the Carrie trial towards the latter half. Yeah, and that's a big problem because people should have time, especially when I call for jury duty. Nope, not working again today, Jamie.
Well, what's the
I
deal?
hate this.
Is something not
I don't know
convicting?
what happened. I do nothing I don't normally do. Let's just say that. So I'll just have to. Oh no, that's the wrong one. I'll have to set up a stream so I can redirect people over to that so they can put a notification on that one. Look, I'm getting better at the grifting. That's because I did this.
Oh my gosh, you guys! There's a class called Basic Grifting. Should we all learn how to be grifters together?
So now I promote my own shows. Not only
you
your.
should.
Well,
You promote more of my stuff that I'm not doing than what you're doing.
But it's because I want you to do it. I told you I'll give you a $50 a month budget to do a show.
I know.
Because at some point, I think a show like that could get sponsors, which all of these shows couldn't get. So
I'd love to be sponsored by all the stuff I buy because that'd be great.
Yeah. I was looking at because someone was complaining that the gift I was giving away, like the candy and stuff like that, they didn't really want that, but they would like water bottles and stuff like that instead. So I was looking at the pricing on that merch store I have. They're not that good. So I need to find some American nuts, your sister nuts, who can make a few for me. Because if I want to make them in Denmark, I can get them at a reasonable price, but then I have to tack on that $15 shipping fee too. So if I could just get some locals to do it, that would be better. And do a giveaway of American stuff. It's probably cheaper than I can't find my own show. But that could be fun.
That's the thing. You got a lot of people now. It's like anybody crafty make like cups. You can make like a prototype for Baker, and then.
Well, I just need. I know your sister had done some bedazzling on cups. I don't need like 1,000, but I could throw some money at, and then you could just ship it for me because it's not like you have anything else to do.
Okay.
No, it's just I don't know. I was looking at options because yeah, it could be cool, but my merch, buying it at the merch store and then getting it shipped to me, I have to pay shipping for that, and then I have to pay shipping. That gets too expensive. So I would like to
Yeah.
find a way to do it because I
And
like doing the
sometimes those
giveaway.
cups aren't the greatest quality either. You can usually buy better quality and make them yourself, but it takes time and money.
Yeah, and I'm not doing a giveaway every week. It's like
Hmm.
but I'd like to do it like once every quarter or something. Have a giveaway on the Stabby Day where you can win something.
That'd be fun.
What brands did her friend with benefit serve in? He was Army. No spunk candy. You can get some spunk candy. Yeah, but again, it's just too expensive to get paid the twice shipping. That's why I would rather have. I did actually talk to an American earlier about being able to do some print runs and then getting it shipped within the US because I have to pay. I pay everything. I ship. I pay $15 at least, and that's just like a bag of Lego. I'll have to pay $15 just to ship it, and the Legos I buy is probably $20. So it could be fun if I can find some local small. If someone has a small little home grift studio where they can print like 10 T-shirts for a reasonable price and ship them, that could be cool. I never understood because we have all these Teespring and all of these big stores, and I know, yeah, they need a big volume because we're not gonna order 50 T-shirts. Me or Vices or Nick or someone won't get 50 T-shirts, but you could still because you don't have to have that big inventory. You can just print on demand. If we say, okay, I'm going to pay you X amount of dollars, get some Fruit of the Loom T-shirts and put this logo on. I think you
Mhm.
can make a little bit of a business side hustle.
For sure.
So it's just yeah, embroidered. Oh, that's fancy work. Why are all the crazy people live in Florida? Dan Davis, it's because they have the sunshine law. So we hear about all the crazy people. Oh, by the way, that influencer I talked about a couple of weeks ago with the pink Coca-Cola in her system, she got upcharged because she was just manslaughter DUI. They got her toxicology back. She has been upgraded because of that.
Oof.
No, it's because all of you are way too kind and sent me money, so I'll do something back for you. It's nice. Do I have underwear? Yes, I lost my pantalones in a bet earlier. That's why I have my underwear. Yeah, but the problem is a U.S. manufacturer. I could probably something stream. I have my Spring merch store where you can, but when I have to get it from Spring and then ship it again, I pay twice shipping. That's twice the price of the merchandise. But I need someone who can do like a print of 10 Fruit of the Loom, and I can give those away or something like that. I have been told I look like Duke from the G.I. Joes. That's why I have him here. Some people have said I look like Arnold Schwarzenegger, but he never had these big hamster chins. I don't know. I just know that there's a brand called Fruit of the Loom. So that's just not, yeah. I have a new slogan for Baker, but I don't think he'll run with it. Baker, hot muffins. Can't eat just one. Hmm. Have you seen those Hamlet underwear? Oh, with the PP pouch. I was told they were good. I never tried them. And I can't figure out if you need to put all put
pee pouch.
yeah, they're called a kangaroo underwear or something like that. There's a I haven't
Like
found
a
out if
banana
it's
hammock?
no. You
Oh,
have
okay.
like my boxer shorts over here, but in
Oh,
front of there's a pouch, and I can't figure out if you have to put the sausage and the potatoes or just the sausage into it.
what? I don't know.
I don't know either.
I don't know.
We can't buy them in Denmark, so I don't know. Zach, I would never accept any of your money, so thank you for not sending me any.
Oh, that.
You know, I don't read your super chats whenever you never super chat me. If you did, I would never read it. That's the thing we agreed on early on. Thank you so much, Zach. It's both. Your neighbor died at 42. Oh, I'm so sorry. And a 13-year-old. That's not a
No.
good. That's not a good way to end the stream. Most say you look like Brad Pitt. I haven't heard that one yet. But Jamie, I have set the stream up to the stream we are going to start in an hour. Everyone, go get your energy up because we will have the defense running. Probably, rumor has it, they will call the now 15 or 6. I still haven't figured out how old she is. 15 or 16-year-old daughter to the stand, testifying that she pew-pewed her dad. And we will get her lawyer to testify something I didn't understand anything of when they did the proffer this morning.
Yeah.
And maybe a tech guy saying IP addresses can be dynamic, but most IPs are not. So that you can clearly connect them. And other than that, I have no idea who they're going to bring, but there might be a Laurie Shaver coming up. Defense will most likely rest today. You have tried to bake homemade bread for 4 days in a row. Wheat flour won't rise correctly. Wheat flour will always rise correctly if you have made the dough correctly. Are you using yeast, an active yeast, or are you using a sourdough to do it? Because it has a lot to do with the amount of time you mix it. Because you need the gluten structure in the bread to form correctly. A lot of people just say, "Oh, the bread or the dough has come together; it's fine." No, you need to the word I can't remember. You need to knead it together more. You can do the gluten test if you're using a normal yeast. Take a ball of dough this size, and then you take 3 fingers and spread it out. And if the gluten structure is correct, you should be able to kind of form it into not a totally see-through window because then it's broken, but you should almost be able to see through the dough by just spreading it out like that. Then you know your gluten structure is strong enough. If you then have yeast with enough sugar to live by and that hasn't been killed by the salt, it'll rise no problem. So make sure you have your gluten structure. If you are doing sourdough longer breads, do that gluten structure early on to make sure you have enough water in it, and then knead that way more than you think you should knead it. Because if you have those long resting doughs with a lot of water in it, make sure that you really incorporate the water into it. It'll be absolutely fine. Have a good day, Dan Davis. Don't kill the yeast with water. That is too hot. Yeah, always have yeast is a is a living organism. So 2 things you shouldn't do. Never let salt touch it before you're incorporating it in the dough. And remember, the temperature of the finished dough should be the same temperature as your skin, because it's the same organism as you. So it likes to be at around 37 degrees Celsius, which is roughly mud pie in Fahrenheit. So the water should be kind of lukewarm, kind of like when you test a baby bottle. Should not be that warm. Running water, get it. It's the same thing. Don't get the water too cold, because the yeast will slow down and can't do it. When you take your dough, your finished dough, put it on the table before you let it rest. Make sure that you kind of roll it into a ball that's tight. Put it under. I always use plastic to put on top of it, because it'll evaporate a lot of moisture. That'll keep it in there instead of using like a towel on top of it. When it's been resting for like 30 minutes, beat out all the CO2, because there's a second growth cycle in the bread. If you don't push out all the CO2 in the middle of it, that CO2 will just kill the yeast. So again, knock out all the air, and then when you form it, make sure it's nice and tight, and it'll rise like a phoenix from the fire. Thank you, Daniel Gutierrez, for 2 gifted memberships. Grey Witch and himself, Daniel Gutierrez. Baker bakes, yes, Grey Witch, but only after he tames the dough. Sometimes the dough wins. Or sometimes my crappy setup doesn't work. Wet yeast. Well, dry yeast is a thing. Wet yeast is a thing. And, what you will call it, I don't know. An opaque window. Exactly, Higgles. I always talk with my hands. And really annoying, because when I'm in a small frame, I can't wave my hands around. Well, baking is a little sexual, and so is cooking, I'm told. But I'm always cooking for myself, so that's not that sexual, if you know what I mean. Yeah, I need to figure out. I don't know what mistakes people are making. If you are trying, I have had people reaching out to me because asking why why is my bread cracking all over the place? Well, you didn't let it rest long enough, so there's more growth. You didn't add water when you put it in the oven. Go into the Discord. I'll try to answer as much as I can. Just tag me in it so I see that you're asking me. Wet yeast is like a putty, like soft clay. Yeah, it's just fresh yeast is probably what you can call it. If you're using a machine, I know every recipe says, "Oh, dissolve the yeast in the water." You don't need to. Just chug it in the machine, let it spin. It'll figure itself out. We've been doing it for 1,000 years. You don't need to do all the fancy stuff, but just make sure water temp roughly 20 degrees, because when you maybe even a little lower if you're using a small machine, because that adds a lot of heat to the dough. Never go above 37 degrees Celsius, because that'll start killing the yeast, because it's a living organism. And make sure if you measure stuff up and put it in one bowl. I normally, if I'm going to bake tomorrow, I will measure everything up tonight and put it in the bowl. And of course, you don't crack the egg and stuff like that, but then you have your salt on this side and your yeast on that side, and you cover all of it with flour, so it'll be fine. Because then everything is room temperature when you start, and you don't have 5 different temperatures, and it's really hard to figure out how to make a dough that's roughly skin temperature when it's done. It should feel a little hot to touch to, but not way too hot, because then you need to lower your beginning temperature. If you're somewhere hot, like Arizona or the hell that's Sweden, use colder water. There is a formula out there how to figure out how hot your water is if you want to go scientifically about it. And I have to figure out what 37 degrees Celsius to Fahrenheit. So your temperature on a dough should be roughly 98.6 degrees. So 98.6 degrees, that's your preferred temperature. How is it? I can't remember but if you're living somewhere hot, lower the temperature in the water, because the flour will be hot. The environment will add more heat into the dough making process. Always remember 98.6 is the optimal yeast working temperature. And never let salt touch the yeast, because it'll suck the water out of the yeast. I don't know why I'm yeah. Danish dough hooks is the best for bread. Well, it depends on what. If I'm supposed to make a bread type dough, you always use the dough hook like that. If you're gonna make anything like a muffin or stuff like that, you use this one, because you want to beat air into the flour and eggs and stuff like that. So you use the K spatula, and then of course if it's anything foamy, you use the whisk. But it's important. A lot of people just say, "Well, now the dough is combined, I'll end it now." No, make that gluten window and see if enough gluten has formed. If you pull it and it just falls apart instantly, it's too tight. So you have overdone it as well. So make sure I would say in a small kettle, 5 minutes is probably around the right time for a dough. So yeah. I never think. So no audio. Just catching up. Didn't think I could cope with the defense today. Feeling rough. Then welcome back at 1 o'clock, because defense will start. Is the AOL sound copyrighted? Yes, I bet you it is. Yeah, that's often the problem, and it'll be flat like a pancake, because you're killing the yeast. It can't produce CO2. What happens inside the dough is, when all of them comes together, all the yeast cells will eat all the sugar. And when you mix water with wheat flour, there are two enzymes in there called glutenine and gliadine. They will make like a you have Mr. Bread here. Inside of Mr. Bread, there's kind of like a net. That net is gluten. That gluten net, if that's not tight enough, all the CO2 will just disappear. But if little Mr. Yeast down here gets too hot, he won't fart out enough CO2 that can raise the bread. So if you make him too hot, he'll die. He won't fart enough, because what he's doing in here is eating all of the sugar, making a lot of farts, and those farts are CO2 captured by the gluten network or the gluten net, and then rising up. That's why you have to push down the dough roughly depending again how hot it is where your dough is resting. But just give it a good squeeze so all the CO2 gets out, because he really likes to numb all that sugar and then fart a little bit more. So there's a department in our oven underneath to raise the dough in. Yes, you can use that. We use it for the trays, but it is originally because there will be more heat in there. So yeah. But I'll have to run. We'll be back in 40 minutes for defense. I'm going to ship you over to the next stream. Please set the notifications, follow on Discord, Twitter, whatever we do and beg for on the YouTubes. All y'all, I'm going to hit the right one on the way out, not the instant close. Hasta la taco. See you later.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
Yes.
All right.